Publicity.
Item number 9, Balo.
Yes.
They have submitted the affidavit in opposition against which I would like to file my rejoinder. I need some time, Balo.
Affidavit on opposition has been filed on behalf of the state or union of
Central government.
on behalf of the respondents.
Yes.
The concept of the petitioner pays for and is granted 4 weeks time to file affidavit in reply.
Deeply.
Item number 18 to 29.
Please, Lordship, we to consider the other side of back to mention item number 18 for adjournment, Lordship. We would like to file an rejoinder, Lordship, 1 week time maybe.
Concept for the petitioner pays for and is granted 4 weeks time to file rejoinder.
Lordship, 1 week, Lordship.
1 week.
1 week.
In that case, a date may be given.
You state what is the date?
6th of
6 June?
6th June.
6 June.
All right.
What is the matter?
It is regarding challenging of the certain conditions of service rules where the government do not allow the persons working in medical colleges to go to other institutions.
Professor, professor matter.
That NOC we are rejecting.
Yes. That this is an urgent matter.
My lord, may I please, my lord, item number 35, 36 may not be taken up today, my lord. Any date.
And counsel, Mr. Saiwala, appearing for the respondents, pays for time to prepare and argue the matters, list up 4 weeks. Hearing list.
Item number 38 to 40.
Another bench. No, both action.
Daily list for orders, item number 1.
Is this your lordship? Lordship, I am appearing on behalf of Mr. S.P. Sudhir for respondent number 11. Lordship, can it be taken up after some time, Lordship?
Why?
Lordship, he is not here right now. He's on the way just 20.
Let's start. He'll join. Don't worry.
Lordship,
This matter is not getting over in moments.
Lordship.
Madam, before we begin, we would like to tell you that we have some reservations on the manner in which publicity is being given to this case. All across the social media. And it can't be without there being inputs. So we are not appreciative of that, we'll tell you. There is nothing to be flouted like anything.
No, we have not given any.
Madam, we are telling you, we have some kind of experience. Don't ask us to comment on that. So please restrain yourself in that regard.
Lordship, with us, only bar and bench had sought for the orders and we had forwarded that on the last occasions.
Madam, we have told you what we are feeling. You just take note of that. Yes.
I had submitted my note to the council,
Yes.
Lordship.
Perhaps the schools, if they put up their stand, then I will stand in
All right.
government knowledge. Schools put up their
Let's
stand.
have a look at the note. Where is the note Madam had given last date? Here. Yes.
Wait, please, your lordship. My lord, I am appearing today, just brief is given to me yesterday, my lord. Item number, respondent number 12.
12.
It's
Yes.
a Cooperative Shishu Niketan situated in North Guwahati, my lord. It's a North Bank of Brahmaputra. It's not a private school, it's a school run under the Vidya Bharati, my lord. Assam Shishu Shiksha Niketan. My lord, already we are giving admission to 18 numbers of students under the RTA provisions of RTA. My lord. I will give the details if your lordship wants to see. And the next thing is, my lord, 3 students who have joined these petitions, my lord, they are reading in the.
This is a Kendriya Vidyalaya.
No.
No.
Sankadev
All right,
Niketan is
Sankadev.
under the Vidya Bharati. My lord.
All right. Yes.
My lord, in these schools, the 3 students they have joined in these petitions, my lord.
Mhm.
They are studying in our schools by paying fees since Ankur and Mukul. Ankur is a class, my lord, which is said in our pre-primary or the maybe say play school.
Okay.
And their fathers, my lord, are working in IIT Guwahati under the Contract Labor Act. My lord, their applications we have examined. If it is found
Contract labor. They are
No, under the
children of
contractors.
contract labor.
No, under the contractors, my lord, not under the IIT.
So
They are working in,
obviously they are laborers.
my lord, we are not refusing their application. We are
You are
not
charging
refusing-
them fees, sir.
My lord, what my instruction is that if their applications are found to be genuine, my lord, because they are studying in our
If
school.
they are found to be genuine, who is to test it?
My lord,
Who is to examine the
they are
applications?
the committee, my lord, in our school, there is a committee. they
When
will
did you
examine-
receive the applications?
My lord, the applications were given to us on
Before
my lord,
March?
in the month of March 2023.
Yes, so is it rocket science to examine
No,
such
my lord.
an
What
application?
my respectful submission is, Milord, we'll return the fees, Milord. The only thing is, these three students have taking classes or studying in our schools since the last 4-5 years paying fees.
Hmm.
So suddenly they have become BPL. That is why it has posed a question to examine the.
All right, you dispose of their application by a reasoned order.
My lord,
They have a remedy against that.
Give, or lordship will give us 3 days time. We'll, if they're found okay, we'll return the fees. And if not, then we'll pass a reason.
Why it took so long, sir?
2 days.
Why it took, why it required presence of Mr. Chamwa to take this decision?
No, my lord, not my decision, my lord.
Then
It was respect.
your advice may be professional advice.
No, not at all. If lordship passes an order, my lord, we'll give it by tomorrow, my lord.
Why do you need the order of this court?
Not order exactly. If give us, lordship, give us
You
time
you objectively consider their applications.
by tomorrow.
If they are entitled,
By
well and
tomorrow,
good.
by tomorrow, my lord.
All right. So
Respondent 12, my lord.
for the timing, yes. You were to respond after all schools have addressed.
The government and what the government has found, my lord, that is have to bring on record, only that part.
So then you should have addressed at first instance.
Schools when they.
All right.
The three students have sought admission to class 7, 7 and 3
Where?
in this particular school. I am addressing first school.
Seventh and third
Third.
standard.
RT does not apply beyond class 1 and the primary classes.
Right.
That he has not put forward, but our report says that it is 7, 7 and 3. So my lord, to enforce the RTA per this school. That
It's not
handle is
permissible under the act
The
itself.
handle is not with her that we can force them.
All right. Okay.
Since
If they
they're studying in their
voluntarily,
school, they should have been given. That is also one of the aspects.
if
Since
they are already
in their school
studying,
from class 1 onwards is the stand, they should have continued to give the RT if the applications was.
all right. Okay.
We'll dispose of their petition by tomorrow.
All right. And tell your clients,
Yes,
they
yes.
have other means of earning income.
No, but
They-
this-
Admittedly, you say the parents, the fathers are working as contract laborers. Where you will keep that money? Charging fees from children of
No, my
contract laborers.
lord. Lordship, I am bowed down to your what lordship fallen from your lordship, smart my lord. The only question poses because of the fact that they are studying in this school last 4-5 years. Suddenly they have filed this.
Yes, now they come to realize that they can get an exemption of fees
Yes, we'll do it. my lord.
on the basis of their income. Mr. Chamwa,
Yes.
what parent doesn't want the child to study in the best of the best schools? Which parent?
Everybody wants. my lord.
Everybody. So we have known to what extent people go to provide the best education to their children.
By tomorrow.
Yes.
I'll come up with a compliance order.
All right. Okay.
This responded to.
Yes.
now. Because they did it.
11 and 17. 11. Who's there for 11? Council has not come. 17.
Lordship, 17, we are not pressing because the last student who had applied, he has taken admission in a different school.
All right.
And
17.
so, the other children have been admitted, it's complied, Lordship.
17. You.
Only one has not.
Okay,
been-
okay.
So we are not.
So
pressing
now
on it.
the grievance remains
With 21
21
and 11, Lordship.
regarding non-refund of fees.
11 is non-refund and 2 children are still awaiting admission.
And
And 17 is Lordship.
17 now you just said
Yes. we
that
are
there
not
is
pressing, we are not
grievance
pressing,
past
Lordship.
17. All right. Record kar lijiye. Then the petitioner present in person submits that as
May I please?
the only child.
May I please, Your Lordship?
You are representing whom?
Yes, Lordship, I am appearing on behalf of respondent number 21, Lordship.
Just hold on. Mr. Chamwa, appearing for the respondent number. You are for the respondent number 7, Mr. Chamwa. 11,
He was
12, submits that the pending applications of the students seeking benefits of the RTE Act shall be decided within 3 days. The petitioner present in person submits that the cause of the grievance against the respondent number 17 does not survive in view of the fact that the only child who was seeking admission in the said school has secured admission elsewhere. All right, now for 21.
Yes, Lordship. Lordship, two students from economically weaker section across our school, Lordship. And
Little louder, madam, please.
Lordship, two students from economically weaker, Lordship, section across our school. And Lordship, for taking admission, although in the year 2023, Lordship, and at the time of taking admission, this was submitted by them, but we refunded said money, Lordship. We refunded said money, Lordship.
Respondent number 21, school had charged fees for admission of Drishtiman Kalita, which is yet to be refunded. That is the note.
620, it was Lordship in my last page of my affidavit, 201.
Yes, Lordship, I have. picture of the
What is your response?
He has a letter dated 25, 2023, Lordship, that they have refunded 4,360. This receipt was not with us. We had only one receipt of some 600.
Sure. Now that takes care.
So that
that-
means
They have refunded. All right.
we did not have this information. Lordship.
All right. Now you have got the information. So that was the only grievance regarding number 21.
Yes, Lordship.
Only one child's fees. What was to be refunded? All right.
Lordship, now I would like to insist. on
Let's
the-
complete
Yes.
21 at least. And council presenting the respondent number 21 has pointed out that the fees charged from the student Drishtiman Kalita has student master D has already been refunded. In this view of the matter, the cause of grievance raised by the petitioner for the said school also does not survive any longer. Now, respondent number, yes, what do you want to say, madam?
Lordship, should I wait for the council for respondent 11, or we can continue with the other argument, Lordship?
What is the grievance against respondent number 11?
No, they have filed an affidavit, Lordship. Their affidavit is on record. The other day it had come.
Hmm.
So,
What have they said?
Lordship, there is no whisper about the two children who had applied in their school serial numbers 27 and 28.
Okay.
And then Lordship will kindly come to their affidavit page 348, Lordship. Running
Yes.
page 348. Their submission was that they never had any information regarding this RTE and 12(1)E, and we had never approached them. On 28th February, Lordship, 28th February of this year, we had sent them an email asking for an appointment to apprise them about this 12(1) RCE, Lord. Page 348.
Order is lying this. Acha, copy hai. Yes. Yes, you send them what?
We had sent them an email on the 28th of February this year,
Mhm.
requesting them meeting for discussion regarding admission under 12(1)C. And their reply, we wanted to apprise them of the children who were in around that area and for the admissions, Lordship. We received a reply from them saying that you are informed, you can meet the principal at his office on any working day from Monday to Friday within 10 so and so after 6th of April. That is, Lordship, why we couldn't wait till then, because after 6, this PL would not have had any effect, Lordship. The dates would have been over. So they gave us a convenient date according to them, but we came to this court. Then again, Lordship will kindly come to page 353, Lordship, of their affidavit.
Just point out the lines from their affidavit that they were unaware of this.
They kept on, their submission was there, but here in the affidavit, they have come up, Lordship.
You made an oral argument that they have stated that they were not aware of the provisions of the act.
That is what the council had stated, but he's referring to our email only now.
You were referring to the affidavit.
I'm looking into that, yeah.
Don't make a misstatement, please.
Lordship page 333. It is further stated, Lordship would kindly come to the last 6 lines, 1, 2, 3, 4,
Yes.
5, 6.
That
It
is
is further
352.
stated that the school of the answering deponent has been dragged in the instant PL without any justified basis or projected.
That is not what
illegality.
you wanted to convey or what you wanted to portray, that they have pleaded that they were unaware of the provisions of the act.
But they
It's
were
nowhere
aware
there
of
from the
it.
affidavit. Please
But they
guard
were
your
aware
words,
of it,
madam.
Lordship, since we had sent them emails, not only to them, to all the schools, Lordship, from February,
Please
Lordship.
don't harp on that aspect. What you stated was not correct. Come out with the substance. Who are the students who have not been admitted or whose fees has not been
Now there are
refunded?
2 students in the affidavit. They have not mentioned anything about the 2 students for whom we are seeking admission.
Okay,
They have given a list of about their activities. Lordship.
Mr. Mazumdar, what about this school 11? What is the strength of the department?
The person at serial number 20, the child at serial number 28.
In this
at page
list?
65, page 65 of the repetition.
Yes.
The serial number 28 and 27, my lord, the grievance remains, if I heard correctly. 28 is for class 3.
Mhm.
Class 3, my lord, the school remains at liberty, my lord, that
They can't be admitted. RT is not applicable.
my lord, from
Let's see.
primary section, and class 1 is what the RTE says. Otherwise, my lord, we can ask
If
them
there
to
is a
complete. That is a
vacancy,
different-
Lordship, they
different issue.
can take
And
it. It is. It
They
depends on
can,
the-
this is not the mandate of the act.
Yes, Lordship.
Yes, so-
And 27 is for class nursery.
27 for nursery.
27 for nursery, my lord, I'm just trying to see. The exception. Hmm. Who is appearing? The affidavit.
Affidavit is silent. Who is the council?
Lordship, we have fixed the matter at 2, Lordship.
No. We are not doing that. Who is the council?
Mr. Choudhury.
He knew that matter is listed at number 1. Anyhow, madam, you
Just,
advance your other arguments.
I'll just trace
Yes,
out my.
Lord.
There is only one student now regarding whom
Yes,
there is a
Lordship.
discrepancy.
Sorry,
So what is your-
Lordship, now I want to press for the central online portal system, Lordship.
Yes.
My prayer is at page,
Mr. Mazumdar, that seems to be a logical prayer.
The central portal system, my lord, it is being developed. We hope it will be there on the next 2 months, my lord. It should be completed.
Why
It's
2
our-
months?
my lord, because that
Now
portal,
there are so many aids available.
the portal has to have, it has different aspects, not
Mm.
only the admission of the students.
Everything,
into
everything.
account, But even the reimbursement to the schools, the verification of the documents, all the documents being uploaded, sent to different departments, feedback per student has to come back. So that is taking some amount of time, is what I'm told. We are test running it.
File an affidavit of the secretary that by what date you will be able to put the portal in place, make it operational fully.
Lordship, my prayer is that this portal has to be in the guidelines and the SOP set up by the NCPC.
Let the portal come into place. If there are any shortcomings, you can point it out.
Lordship, there's another thing which I want to rely on. Supreme Court had taken this matter, Lordship, regarding the portal. And on 9/5/2022, this order was passed, Lordship.
Let's see.
And later on, all the chief secretaries of the state have been asked to come up
So
with
if
it.
the Supreme Court is seized of the issue, why are we supposed to intervene then?
Lordship, this is for the central online portal system. Lordship, there's already an order and it has already been communicated to all the states. Lordship. Lordship, on 31/5/2022. Government of India from the NCPCRC sent a letter to all the chief secretaries of the states, Lordship, and pursuant to that, paragraph 22, most of the states in India have done it, Lordship. Rajasthan is the first state, Lordship, who have complied with it.
And that we expect. Rajasthan, as a matter of fact, the Legal Service Authority had taken up a big drive for bringing back the school dropouts back to school. It was a huge drive and it was immensely successful.
Lordship, states like Uttarakhand, Uttar Pradesh, paragraph 22, I have stated, Lordship, which states have adopted, and it is completely in place, Lordship. After this letter came out in 22
Para 22.
of my PI Lordship, page
Yeah.
23,
Hmm.
states like Uttarakhand, Uttar Pradesh.
All right, let's,
Chandigarh-
madam, let's have the affidavit of the secretary.
Yes,
You see,
Lordship.
Assam is also doing well, don't worry. So they are already into the process. Let them put up a portal which is free of all glitches. Let the portal come up.
Yes, Lord.
Let them take time, but put in place a system which does not have any hassles.
Yes, Lordship.
So let us have the affidavit.
That one single child who remains, my lord, I had filed in one of the reports of the secretary on 23/5/2023. It says that one student treated us is out of station along with their parents. When we made attempts to contact the parents, this is the report which has come from the inspector. The office of the director had also made attempts. They were not available at that particular point of time. They have not reverted back. We will take it into.
These are excuses, Mr. Masood.
My lord, I understand, my lord. These are not excuses, my lord.
It's
If a
simple
person is
excuse.
out of station, my lord, they do not come to us.
So, and you read
make a
this
second.
order, madam, has placed, read para 9.1.5. Even if the child is
Yeah.
above the age of 14 years
My lord, yes.
and does not fall under the purview of RT Act, the child can be considered.
My lord, that would be when he continues the education. In the
Drop out,
same-
drop out. Read the order, please. And this order is a guideline. And when you prepare the portal, you have to take into account these directions also.
That the child of 6 to 14 years old should be considered out of school if he has never enrolled in an education and if after enrollment has been absent from school without prior intimation.
So this is basically the idea is if this child is forced to drop out because the parents do not have the financial resources, then the RT Act he can definitely claim. Then that would be subject to availability of of course, vacancies.
Lordship, the OM also allows. That's, Lordship, there is even a.
There can't be any such constrictive view.
Well, my lord, I have had a discussion with the secretary, my lord. He is very open to this. The director is open to this. We
So
can- we
you
have to
just
convince
provide
this
this,
to.
provide this judgment to the secretary, file the affidavit. After 3 days, 4 days, we'll take it up again. Okay.
My lord, next week I will not be here for a personal, my lord.
Or when do you want it?
Anytime
June?
the week after, my lord.
12 June?
You-
Uh,
12th I'll start back, my lord. 13th could it be 13th?
Lordship, I have another small submission. The schools should reflect in their websites about 12(1)(c). That is the note the other day, Lordship, which I had submitted before this court.
We'll answer, we'll pass an order.
So, no, the order is already there. Lordship will kindly come to my note,
The
Lordship.
affidavit will contain assertions to the effect that if the schools will be directed and non-performers will be taken care of.
We'll do that.
Lordship, this notification has come out after our PI on last month, Lordship. Lordship, may please come to
Page.
page 5 of the note which I had submitted, Lordship.
Yes. No.
This note
No.
which I submitted the other day, Lordship.
Just,
You need to come and say, I can't see this thing.
Mr. Mazumdar, see the material she has placed on record.
Yes,
They are all relevant facts to be taken into consideration. This is your note.
page 5 what question, no? Page 5, yes, my lord. Mission Director and DSC will take necessary action regarding issuance of admission form, ensuring that the respective unaided non-minority schools are also made to issue the same notice on or before 15/3/2023. Then the date of admission under section 12 shall be fixed by the Mission Director so-and-so and DSC Assam as per government PMA number so-and-so for the academic year 23/24, which is yet to come. Subordinate officers under the Department of
Lordship,
School
He
Education will
has missed out
announcing the same through websites,
Regional
regional newspapers and
relevant
yes,
media.
we have already passed the order 23/24 session. We will be really very careful, my lord, that is.
This is 23/24.
Before the session starts, all these things should be.
By, my lord, what I had suggested, it is yet to be discussed. What I had suggested is by December, schools can tell us. These are the number of.
These details should remain live always.
Yes, yes, yes.
There is no need to fix a date. They should always be available.
Every year by December, they tell us the number of.
Number of seats available, yes, yes.
And the day the admissions are over, they can tell us that these are the
These are the
students we have admitted
Precisely.
and these are the students we could not admit for
Incorporate-
such and such.
incorporate all these facts in your affidavit.
If they already have an activity calendar, they need not make a new one. The OM already has an activity calendar.
All right, we understand, madam. Let
Everything
this be.
is Their lordship in this OM, the only thing which we are praying for is.
Schools should also put up the information
schools
in their
should
website.
also in their websites, put up a page saying that they are open for 12(1)(c) admissions.
Yes, Mr. Mazumdar,
Yes,
that is a valid submission
Will-
regarding the child yet to be admitted, child who is awaiting admission in the school, respond number 11, comma, Mr. Mazumdar submits that appropriate proceedings are being taken in this regard. Also, he further submits that a detailed affidavit will be filed on behalf of by the Secretary of Education, setting out the steps proposed to be taken by the state for proper compliance of the RTE Act.
Lordship, one last prayer, Lordship. My friend said that class 3 they cannot take, but the OM Lordship at page 40, it says the unaided, clause 11, Lordship, I'm reading, the unaided private schools shall admit children under section 12(1)(c) and RT as per neighborhood norms, Lordship. A is for children residing within 1 kilometer for getting admission. into
Otherwise also,
classes
madam,
1 to
the
3.
Supreme Court judgment also says
Yes,
that
Lord.
they are not prohibited from getting admission. So please ask your authorities.
We'll do our part.
It is very clear, Lordship.
List on 13 June. Only 11. Respondent 11's council, if the council comes, maybe we can talk. You talk to the council, resolve it. Only one student left to get.
Lordship, 2 students, in case
Two.
they are willing, they can give it to the child in for class 3 also.
Mr. Mazumdar, there is no harm. One child will study,
There is.
good for the society.
Much obliged, Lordship.
The school who admits children who are even not entitled under 12(1)(c) and give the benefit, they should be given bonus marks. In such a situation, many times it so happened that lawyers would step up and say that we adopt the child. We bear the expenses. That used to happen. Maybe inspiration may.
I'll convey my lord.
Much obliged, Lordship.
Item number 2.
May please allow.
Yes.
Lordship, with due respect, Lordship, before going into the impugn order, Lordship, kindly
Yes.
peruse page 38, Lordship. Lordship, here in this case, Lordship, initially, the present petitioners filed an application.
2 months only your application was filed.
Lordship, earlier occasions, Lordship, that is page 38. Earlier occasions, Lordship, I have filed an application. That
Hmm.
application filed before the revenue circle officers, Lordship.
Yes.
38, Lordship, 38. Lordship, that application has been forwarded to the DC office, Lordship,
Hmm.
inter records, Lordship, along with this whatever order passed, Lordship. Lordship, that record has been misplaced.
Hmm.
Till date, Lordship, not trace out. That's why, Lordship, a petitioner submitted another application before the DC, Lordship.
Cost easy kar dete. Cost easy kar dete. Then around the application, first one was misplaced by them. Second one, he filed in that check requested. Ye jaldi tey kar dijiye. What do you say? You lost his first application.
Yes.
He came up with a prayer, ask him to decide my application quickly.
Pending is pending before the deputy commissioner, and the deputy commissioner will decide the issue.
Heard and counsel for the parties, there is the impugn order and the appellant is aggrieved of the non-decision of her application for settlement
Yes, Lordship.
pending before the deputy commissioner,
Kamru Metro.
so and so, which was submitted in the month of February 2023. Before that, the petitioner filed an application to the circle officer in the month of July 2022, which was forwarded by the circle officer to the Deputy Commissioner by communication dated 14/7/22. However, it seems that the said application has been misplaced and thus was not processed. Full stop. The writ petition of the petitioner came to be dismissed by the learned single bench on the premise that it was premature and sufficient time was not given to the authorities to decide the application. Full stop. We are of the view that as the earlier application of the petitioner appellant was misplaced by the authorities, she had the rightful grievance that the subsequently filed application should at least be decided expeditiously. Thus, the impugn order whereby, writ petition was dismissed with a cost of rupees 5,000 is reversed. The cost of rupees 5,000 imposed by the learned single judge upon the petitioner appellant while dismissing the writ petition is set aside. The Deputy Commissioner concerned shall expedite the process of deciding the application filed by the petitioner. The writ appeal is disposed of.
Highly honest.
Item number 3.
Just for the dropped staff matter.
Yes, my lord.
We'll fix all the petitions together. How many appeals are there?
Till now, 8 appeals.
Eight.
More
More are likely in the pipeline.
Yes.
in the pipeline.
This is a matter relating to the dropped staff, dropped teachers,
Teaching and non-teaching staff.
teaching and non-teaching staff whose claims for regularization were not accepted
No,
and
not regulation, pensionary benefit.
pensionary benefits were not accepted, and the writ petition came to be dismissed by learned single bench. Issue notice to the respondents. Mr. So-and-so puts an appearance on their behalf. Connect and list with similar writ appeal number so-and-so.
Writ appeal number 156 of 2023.
My lord.
And
The registry shall seek instructions for joint hearing of all analogous appeals.
You lost it yesterday, you lost it fixed after 6 weeks.
We'll connect all the appeals.
Item number 4.
So
is
also similar order.
And so obliged.
Highly obliged.
Item number 5.
Madam, the petitioner has been appointed by the department, madam, on 25/5/2023 as the subject teacher.
Affidavit. Provisionally, he was permitted.
But
What do you want to point out?
and she has been appointed, madam.
She has been appointed,
Yes, sir.
so no grievance.
No grievance right now.
How could she have been appointed?
But she has been selected, madam, on merit. And
We directed that the result shall be kept in seal cover.
but they have appointed, madam.
Mr. Mazumdar,
No, she will give me till 2 o'clock, my lord, I'll find out.
this is remarkable. Qualification not. Maybe they might have passed the order, meeting or visit to be equivalent. It's quite possible. Possible.
Item number 6.
My pleasure, Lordship. In this case, Lordship, on last Monday, we have taken steps, Lordship. Lordship, we have filed a additional reply of the affidavit filed by the respondent, Lordship. That is not tagged with the record, Lordship. That is not tagged with the record.
You have filed the affidavit.
Yes, Lordship.
When?
On last Monday, Lordship, on 29, Lordship. But we have filed, Lordship.
But you have not even given a copy.
Yes, we served a copy, Lordship.
From council, MS Mason.
With the
Representing
with the, reply, Lordship, can it be taken up on 6, Lordship, if possible?
That she has filed an affidavit in reply on behalf of the petitioner. The registry to check and tag the same with the record. Copy of the affidavit be provided to the government council, MS M. Bhattacharjee.
Page 165.
So it's already there. That's M. Bhattacharya's affidavit, sir. The petitioner's counsel. Affidavit in reply, the rejoinder affidavit.
What was this?
Actually, it should be rejoined. ये proper नहीं है अपने यहाँ पर ये सब। चलिए,
That's why I got confused. Initially, no position.
On sixth, Lordship.
list on 6th June as per it.
Published.
Item number 7.
Please, Your Lordship. Lordship, this PIL pertains to infrastructural constraints in the State Consumer Disputes Commission.
They filed an affidavit.
Yes, ma'am.
Yes, Lordship, they have filed an additional affidavit and we also have prepared on status report, Lordship. May I be allowed 2 days time, Lordship? to
MS
place this on
Bhattacharya,
record,
please
Lordship.
for and is granted 7 days time to present latest status report regarding the
Lordship.
issues raised in this PIL petition list on 12th June.
Deeply obliged.
Deeply obliged.
Item number 8.
May appear, Your Lordship. Lordship, in spite of service of notice, the still respondent is not appeared. The writ petition is filed against the order.
You file a writ petition after 3 years of the CAT order. What is the reason for delay? CAT order is of 2019.
Yes, Lordship. It was filed in 2022, Lordship.
So that's not 3 years. Have we erred in counting the years?
Lordship, here,
Yes.
the petition, the respondent was
They
granted.
have, the relief has been given on parity.
Lordship, that is not correct, Lordship. But he is not covered by that judgment of Ernakulam bench, Lordship. Here he was appointed as the translator.
All right. No one appears for the petitioner despite respondent despite service. Admit issue notice. Steps for service be taken within 7 days, whereafter process be issued.
Item number 10.
There are 6 and 7.
Alert.
Yes.
In this case, government has filed already affidavit, my lord. I may be allowed to file a reply, my lord. 2 weeks time, my lord.
And council. Qualified when you file. OM type condition that you can grant it in a different department. But that is unreasonable. Those department के लोगों के लिए क्यों देना दूसरे? Not as a matter of right, basically.
And it was subsequently blocked.
Yes,
Lordship, we have placed the instruction on record only, nothing affidavit in opposition.
only instruction.
Yes, Lordship.
What is the
As Lordship
instruction?
directed.
What is the
Lordship, it has been considered, Lordship, the 5% in other.
He has already been considered.
Yes, Lordship.
Where is that? Let us see.
Lordship, most probably the affidavit is not tagged, Lordship.
No, it's there. That is an affidavit of the appellant. Minutes of meeting dated 13/9.
No, not
There?
that, Lordship. We had a instruction, Lordship, that regarding the section,
Clause
clause
15.
15, yes, Lordship, of the, this OM dated 1/6/2015, Lordship. So this 5% vacancy, Lordship, are in the other departments also.
Okay, this is the note modalities for compliance.
Lordship,
This is a half-page note. Which is the note you are referring to?
Lordship,
filed
this
an
is an
affidavit.
instruction from the Deputy Commissioner, Lordship.
You filed an
Yes,
affidavit or a
yes,
note?
Lordship. Yes, Lordship.
Learned Government Council. MS Bhattacharya submit that she has filed affidavit on behalf of the respondents yesterday. Counsel for the petitioner, the same be brought on record. Counsel for the appellant. Praise for and is granted 4 weeks time to file. Counter thereto.
Obliged, my lord.
Item 11.
I think, my lord, in this case, notice has already been issued. They are supposed to file affidavit. Took time for filing the affidavit.
Sent it for getting my lord, 2 or 3 days time.
Principal appointment. Provincialization. Provincialization. Yes. That is the reason. Mr. Mazumdar prays for and is granted further opportunity of
A week, my lord.
1 week to file affidavit on behalf of the respondents.
Status quo is there. Interim
Status
order-
quo order shall continue. Passed earlier shall continue.
Item number 12,
May I please your lordship, as per verbal instruction, lordship, appellant is appointed, lordship, as Gao Pradhan.
Affidavits
Appellant is appointed as.
has been appointed.
Yes, Gao Pradhan, as per verbal instruction, lordship. Verbal.
You have information.
Lordship, I have been appointed, my lord.
All right, then the appeal can be disposed of then.
Lordship.
What more remains? Hmm.
Lordship.
All right, then council. So he has been appointed by virtue of the stay passed by this court or
Yes,
formally?
No,
by virtue of the.
What happened to the appeal?
appeal is pending there.
Regarding order of the appeal.
You're stating so on the basis of appellate order. Let that order come on record then.
Lordship,
Lordship.
When will you be able to bring?
after 2 days.
Today's MS Boda submits that the appeal of the respondent has been decided and the appointment of the appeal preferred by the writ petitioner Ikramul Hussain.
No.
Then-
He was the writ petitioner, my lord.
That's what we are saying. Ikramul Hussain was the writ petitioner.
Yes, my lord.
The appeal preferred by the writ petitioner Ikramul Hussain,
Sanwar Hussain, lordship.
Sanowar Hussain.
Writ petition is the respondent.
Sanowar Hussain has been decided and pursuant thereto, the appellant herein has been appointed as the Gaon Pradhan.
Gao Pradhan.
All right, she may bring the order on record list on 7th June.
Deeply.
item number 13,
Yes.
Some more time may be granted to.
Yes,
Lordship, some time may be granted to file affidavit, Lordship.
a matter of liberty.
Lordship.
My lord, they on the last 2 occasions, your lordship,
The sensitive cases,
my lord, the thing is that
we
uh,
will give them last opportunity.
Lordship.
my lord, at least a week's time, my lord, max to max a week's time. Because what happened, my lord,
Appearing for the respondents. Respondent is granted last opportunity of 10 days to file affidavit on their behalf.
my lord, the correction order also has been filed, my lord. That,
Mr. Burgoyne submit that he has already filed the application for correction.
my lord.
The same be brought on record. Last opportunity is granted to respondents council to file affidavit in terms of the earlier liberty list on
6,
not 6th. 8th June,
my lord,
not 8th June, 10 days time they are granted. 12th June.
my lord.
Yes.
item number 14 and 15,
Wait, your lordship. Your lordship, the state respondent is supposed to file affidavit in both the cases. Last occasion, your lordship, they have been granted time, lordship.
Pick it up, no, 795.
No, it's a black thing.
You challenge the same.
Yeah, lordship.
The rules which have been challenged in a bunch of other petitions related to the same act. And almost the same category, my lord, why teachers are not being equated with teachers.
Mm.
Those matters are 7955/2017. If
Yeah,
it's
let's
taken
see
up
the-
with them, in the meantime, we can complete our pleadings, madam. I'll file my affidavit.
Yeah,
you can file
lordship,
it.
the issue is slightly different.
Just can't make out what you are trying to say. Little louder.
There is a other set of writ petitions
Hmm.
where provisions of the same act which
Yes,
has been challenged here, including these provisions are under challenge.
are under
between different-
challenge.
They are, that is WPC number 7955 of 2017, which are now listed for final hearing. If
Okay.
this matter is taken up with that, we can complete our pleadings in the meantime and have it disposed, it can be considered all at a go.
What do you say?
Lordship, here, Lordship, my issue is, Lordship, defined, Lordship, to there's repetition, Lordship.
All right, you let them file the pleadings then.
Yes, Lordship.
You make a mention in your pleadings regarding the other pending writ petitions.
I'm having the bunch of those cases where these section 2, 6, and 3 have been challenged.
Mm.
But here, Lordship, the petitioners agree by the section 8, 3, and 8, 4.
All
That
right.
is not the issue in the earlier
Alright.
that's a big petition, Lord.
Standing counsel, Mr. Ozumdar praised for and is granted further opportunity of 4 weeks to file affidavit on behalf of the
State respondent.
State respondents.
all respondents,
Yes, sir.
state respondents
Obliged.
But the finances also there, I'll file for the education department.
for the education department.
Also, may I pay for a date, Lordship, after 4 weeks, Lordship?
4 weeks. That goes to July,
Yes, sir.
list on 19th July.
Deep level list.
Item number 16.
May it please the Lordship.
Yes.
Mala, this matter, the writ petition is before your Lordship because of a reference made by the order dated 18/2/22.
18 to 22.
If I am not wrong, Mala, 18/2/22. Where Mala, there,
First February. Oh, I've seen that. Yes.
Mala, there are two single bench judgment where in the 18/2 of Assam Land and Revenue Regulation, one judgment of 2006, GLR page 99, says that notice is not required to be given. And a person can be, if he has no right as a landholder, settlement holder and others, he can be evicted forthright. Malad, another judgment of 2018, 1 GLR page 30, Malad, where it speaks that no, he should be given an opportunity by a notice so that he can at least.
So now we have to resolve the conflict in two views.
Two views, Malad, one.
Then it goes to a full bench, larger bench.
Larger
If there are two divergent views of the division bench,
No,
either we, then
two single judges. Malad.
single judges, all right, then it's okay.
Malad, now, Malad, let me finish. Now, Malad,
No,
there
if-
is a judgment
Mr.
provided by the
Mr.
government advocate.
Ms. Counsel, this judgment at page 50, that is a division bench view.
Malad, what that I want to, I have seen, they have given a judgment
Hmm.
of a division bench,
Hmm.
where Malad, in para 15, they have said, the division bench said that notice was provided. In
Hmm.
that judgment also, your lordship will find in para 15 of the judgment, where notice was provided, my lord. Moreover, we find that the ejectment notices contain.
No, notices are given, that is a different thing.
My lord,
Whether it is mandatory to give a notice or
my
not.
lord, here it has decided only a summary procedure can be taken into.
Yes, yes.
But not that they have not decided on the issue of whether notice is given or not to be given.
That's what, so
That
this
is-
judgment is not
No.
conclusive on the controversy.
Controversy. That is
Yes.
why I am before your lordship. My.
So once let's see here, the matter is only when we propose, when to both sit together and make it part. You are prepared today?
My lord, I am prepared. My submission before your.
Respect of the matter, my lord, with all humility and humbleness, I am submitting, my lord. And my lord, Justice Chaudhary may not be pleased to take up this matter. Because, my lord, the second decision, my lord, that
You were, my lord,
demolition.
my lord justice.
It doesn't
was a
make any
counsel.
difference.
Was only a council, my lord. That doesn't
Was a
matter.
counsel in one of the
Doesn't
cases.
matter, my lord.
Even
It's
if,
not a
even,
judgment.
you know, now this is a reference to the division bench. Even if the judgment was passed by Justice Chaudhary, he is still entitled to hear the matter.
My submission before your lordship, my lord, in both the ways, if I count, my lord, I would support, my lord, because the notice should be given in pursuance to the 1978 judgment of Menox.
Then you, all right, you formulate your arguments, we'll fix the matter on a date,
My lord.
argue it finally.
My lord.
List the writ petition for final disposal on. And we. We will particularly have a formal bench with the next week in your. Benches will just go. Fix a date at 2 o'clock Wednesday. And we will get it. I have no vote. List before a bench to be constituted, especially on 15th June at 2 p.m.
15th of June, my.
15th June, 2
I'm
p.m.
so grateful. I'm so grateful.
No, it's 16th June, 2 p.m.
16 June.
Yes.
I'm so grateful.
Item number 17.
May it please, Lordship, in this petition, we have filed an IA of impleadment.
Yes.
The Andhra Pradesh State Fish Farmers Association. Lordship, in the pleading, it is stated that we are the main importers, and in the prayer, there is a prayer for direct ban on importing. Lordship, any order passed in this petition will directly affect us. Moreover, as farmers, we can assist this court how the supply comes
All right.
and how.
What do you say, madam, to the impleadment application?
My lord, my only concern is 2 points. The first is the reason assigned is that they will be affected in monetary terms, on business perspective.
That's all
And
right.
second thing, my lord,
If
the,
they are able to explain that they are not responsible for this, then they let them intervene.
Lord,
So
there is-
PIL doesn't make, it's not an adversarial litigation.
the only second thing is, the second thing that the applicants have contended
Yes.
is that we have prayed for a complete ban on import of fish from any state.
Mm.
But if your lordship kindly has a look. at
No,
our
we are not
prayer,
accepting their
it is-
contentions as such. We are not adjudicating upon that. In this IA,
And our prayer is not for complete ban. Our prayer is that ban on import of fish from other states until it is ascertained that the fish are healthy for human consumption. And now the state government, the Food and Safety Department, has already filed an affidavit wherein it is clearly proved that in a number of states, the test has come out to be positive. The containment of formaldehyde is in the positive.
mm,
So, my lord, and secondly, my lord, the Fishery Department has also filed an affidavit
mm,
at page 68, my lord,
yes.
whereby it has stated that in this regard, you are requested to make necessary arrangement to purchase formalin testing kits. My lord, if formalin testing kits were not available with the state, then how this incomprehensive report, which has been placed before your lordship, is being relied upon?
Now, madam, firstly, we are addressing their application.
My-
That is on the merits of the matter.
My lord,
So, like, IA number so and so filed by then Counsel Mr. Bora on behalf of the applicant so and so is disposed of with the direction that the applicant shall be permitted to act as an intervener in this matter. Yes. Now, list on 8 June, 7 June.
give you the.
Yes, take that.
Supplementary list, item 48.
What happened to the top of the list?
May it please, Lordship.
This is.
May it please, Lordship, because my learned time, biggest my English, what happened in this case, my lord?
No, there was one petition we restored and then directed that it be coming up. The restoration, the file was there. I've read the file. It is listed in the hearing or what? Maybe.
Maybe in
Hearing, I've read the file. Yes, Rukjyoti. No, this July. Yes. No, it will come up. Yes.
In this case, my lord, we have filed a caveat, my lord, but the caveat has not been implemented as responded, my lord, in the TJP, my lord. Although we are a national
Not
party,
been implemented.
my lord.
Second one.
Was the cavator party in the,
Yes, my lord.
why
No,
not?
we have filed a separate division.
Direction,
Two
direction of the learned single judge is to consider, I mean, not to give settlement with the highest bidder. And my learned friend's client was the second highest bidder. And since the direction,
Irrespective, sir. The fallout may be benefit the cavator.
I'm not disputing that, maybe.
So then why you are proceeding without impleadment?
No, let my learned friend, I mean, get.
No, but this is unfair, sir. A party in the writ proceedings not being impleaded in the writ appeal.
My lord, so one thing I must point out before election, in view of this order, my lord, whether my lord, Honorable Justice Chaudhary will take up this matter, my lord.
What order?
Hey,
देना भाई single bench में कोई stay किया?
So, my lord, the learned single judge disposed of two matters. In this case, we are filing the appeal against the writ petition where the, my learned friend's client is not even a party.
Are they the same parties? कोई decide करना पड़ा. ये है ना इसमें link case. Yes. Please before a bench of which Honorable Justice A.D. Chaudhary is not a member.
My lord, only problem is, my lord, the pursuant to the order, now they might come up with a settlement order that tomorrow, my lord.
Tomorrow. In the meantime, you implead them.
No, my lord, what
Non-impleadment
happened? I couldn't.
Non-joinder of
No, my lord, not on
parties.
that. There were two writ petitions were disposed of by the learned single judge.
Okay.
We have filed writ petition, appeal against the writ petition where my
He is not
learned
a
friend
party.
is not a part.
All
That's
right.
fine.
in the second petition, we had the writ petition, my lord.
But then there is the appeal doesn't arise of that writ petition.
Yes.
No, this is common judgment, my lord.
Maybe so,
Common
sir.
judgment by.
Maybe.
Common
Sir,
judgment
you
by-
are not a
My
party in the
learned
writ.
friend's client haven't got any relief that way, my lord. That's why, my lord.
Leave it to the government, my lord. Government will decide, my lord.
Mr. Counsel,
My lord.
if you are not a party in this particular matter, there were two writ petitions, maybe you are party in one writ. But if they file a writ appeal in the writ petition wherein you are not a party, you are not supposed to be implemented.
Exactly.
No. Wait, this is a common judgment will pass in the two writ petition, my lord.
Right.
Both the
Then
writ
you
petitions were
move an
accepted,
impleadment application then.
my lord.
Otherwise, we will not permit you to act in this case.
No,
Move an
already-
impleadment.
No, that's already we have filed, my lord.
Impleadment.
Yes, ma'am.
All right, we'll see tomorrow.
Published, my lord.
We'll send it to another bench. Okay.
Item 49.
Will not disturb us.
Well, after going through the gravity of the projection made in the petition, well, I contacted the SP and took a report. But I'm just handing over the report now.
Yes, please.
Well, if lordship kindly comes to page 14. Well, these are the persons according to them. My report says, well, the Rokia Khatun, she has been arrested. And Sukhjan, she has been released. Serial number 4, she has been released. And Shahinur, she was arrested and produced before the court and learned
14?
6, serial number 6. He was arrested and produced before the learned court below. Court below has given 3 days remand.
All right.
And the other persons, my lord, they are the mothers, my lord, they were in fact section 41 and section 160 notices were issued to them for appearance. Because my lord, I have given the report, my lord, it's a connection with a 302 murder case, my lord. Some investigations were going on. Some my lord, the materials are there that they are harboring the accused person, my lord, who has killed who has committed the crime. And they were for interrogation purpose, they were called to.
Females.
Correct.
How long females can be kept at the police station?
No, my lord, section 160 notices were given to them. And my lord, they were not arrested, my lord.
How long were they kept in the police station? Where are they now? Arrest shown after filing of the writ petition. Very smart proceedings. Have you installed CCTVs in your police station?
Yes, my lord,
We'll
nowadays-
call for the footage.
I'll get,
You call for the footage, you yourself see the footage.
lordship, I'll do that.
And what is the status? You have shown or arrested when?
Malad, the
31st May.
31st of May. Malad,
That was yesterday.
yesterday, the Rokia Khatun, the first lady was arrested.
Yes.
But this Shahinur, Malad, this number 6, he was arrested and produced in 3 days.
4:30 AM. Mr. Nath,
Malad,
look at the pleadings.
correct, Malad.
On 25/5/23 at about 4:30 AM. The victims, namely so and so, were picked up and detained.
That is the allegation made, and considering that, Malad, I asked them to give me a report. This is a preliminary report, it has come. I'll get a detailed report, Malad. But the thing is that, Malad, the person, the Shahinur, he has been arrested and 3 days remand. Learned Court has already-
Shahinur, we are not bothered.
Not yet.
They are
As you can
talking
see-
of Rokia Khatun,
Rokia-
Rakibul Islam. 10 years. Somia Yasmin, 6 years.
See, Malad, they are the children, Malad, with the mothers, they came. They were
How
not
could you take them to the police station, sir?
Malad, let me get the detail, Malad. Let me get the detail.
Keep your SP present with the report tomorrow.
Let me have the.
Let your SP be here with the entire record, SP and this SHO concerned, CO concerned.
Got it.
Mr. Nath appears for the issue notice. Mr. Nath appears for the respondents. He shall keep the SP Dubri shall remain present in the court with the complete record tomorrow, tomorrow. The CCTV footage of the police station shall also be kept available from 25th May onwards. Shall also be kept available.
Daily list, item 19 for final disposal.
May it please your lordship. My lord, basically, we're challenging, my lord, the validity of a regulation framed by the state in exercise of power under proviso to Article 309 and the consequential selection process, my lord. Now, my lord, just to give an
Does
idea.
that matter? APSC and that's what
That board.
board.
My lord, kindly permit me to read 3 paragraphs from.
What has happened to the selection process in question?
Going on, my lord, because lordship has not interdicted with the selection process. Yes. My lord, I may be permitted to place 3 paragraphs from the petition where, my lord, our case has been premised, my lord. Please come to page 19, para 21.
Note karo brother here.
Page 19, my lord.
Check note. Yes.
That the fundamental issue which arises for consideration in this writ petition is whether state government governor in exercise of power conferred by proviso to Article 309 can override the constitutional mandate contained in Article 323 of the Constitution. The further issue which falls for consideration is whether power conferred upon the governor by proviso to Article 323 can be exercised by the governor in exercise of power under proviso to Article 309 of the Constitution of India.
Yes.
In the humble understanding of the petitioner, answer has to be an emphatic no, in view of the fact that exercise of power by governor under proviso to Article 309 is subject to Article 320 of the Constitution of India. That having regard to the aforesaid legal principle, the notification dated whereby Assam Technical Education Service Rule 1981 has been purportedly amended by Assam Technical Education Service Amended Rule.
This will read. You're reciting from the paragraphs. What is the point? This will read.
Yes.
What is the foundation? What is the judicial pronouncement?
Yes.
What are the
Now,
provisions?
my lord will kindly come to the Constitution first, then I'll come to the other provisions, my lord. So I'm just reading the 3 paragraphs to lay my foundation, my lord.
We understand. We understand. Come to the provisions.
Yes, come to
Constitutional
Article
provision.
320, my lord.
Yes.
First 309, my lord. Subject to the provisions of this Constitution, acts of the appropriate legislature may regulate the recruitment and condition of service of persons appointed to public service and post in connection with the affairs of the union or state. So ideally, my lord, to lay down the condition of service, there should be
act of the appropriate legislature. However, the proviso, my lord, provided that it shall be competent for the president or such person as he may direct in case of services and posts in connection with the affairs of the union and for the governor of a state or such person as he may direct in case of services and posts in connection with the affairs of the state to make rules regulating the recruitment and condition of service of persons appointed to such service and posts until provision in that behalf is made by or under act of the appropriate legislature. My emphasis would be, my lord, on the very opening word of Article 309, subject to the provisions of this Constitution. Now, my lord, will kindly come to Article 320, sub-article 3. Union Public Service Commission or State Public Service Commission, as the case may be, shall be consulted in matters, my lord, relating to A to E. Then, my lord, will kindly come to the proviso. Provided that the President, as respects all India services and also as respect other services and posts in connection with the affairs of the Union, and the governor, as respects other services and posts in connection with the affairs of a state, may make a regulation specifying the matter in which either generally or in any particular class of case or in any particular circumstances, it shall not be necessary for the Public Service Commission to be consulted. In any case, my lord, if the governor of a state feels that having regard to the administrative exigency, the consultation as contemplated is to be dispensed with, then, my lord, a regulation has to be made under proviso to Article 323, not under 309. My lord, Assam government is conscious of the fact. That's why, my lord, the APSC limitation of function regulation 51 has been framed under proviso to Article 320. The question is, how can a regulation framed under proviso to 309 can take the place of an exercise which ought to have been undertaken under proviso to Article 320? My lord, it is not my submission that under any circumstance this, consultation can be dispensed with. It can be done. But it has to be under this proviso. Now kindly come to the regulation, my lord, which has been framed by the state, my lord. My lord will kindly come to page 77.
Yes.
In exercise of the power conferred by proviso to Article 309 of the Constitution of India, Governor of Assam is hereby pleased to make the following regulation in respect of the composition and staff of the Assam Engineering Services Recruitment Board, etc., etc. So it is an exercise under proviso 309, not under proviso to Article 320. So in that, I think, my lord, I don't think I have to go anything further. This goes to the root of the matter.
Okay.
Now, my lord, kindly come to page 78. This is regarding the constitution of the Assam Rule 3, my lord. Regulation 3. Constitution of the Assam Engineering Service Recruitment Board. Then, my lord, at page 83, the recruitment process is specified.
The board, we presume, has been constituted.
Yes.
It has been?
The board has been constituted. Procedure of recruitment at page 83, recruitment process. The board shall conduct the recruitment process and make recommendation. Now, under the relevant service rule, my lord, earlier it was a PSC, Public Service Commission. Now, by an amendment, my lord, they have
Board has been
amended their
substituted.
provision. So instead of
Which
commission,
you
they have brought
probably
in
missed
board.
out in the first writ petition.
Yes, yes.
Yes.
So therefore, now my simple case is, my lord, how can state, by exercising power under proviso to Article 309, which is subject to other provisions of the Constitution, including a proviso to Article 323, where is this scope? My lord, I'll place 2-3 judgments on the point, my lord.
Yes.
Basically, this is my case, my lord. Please condition. My lord will kindly first have 1995 Supply 1 SCC 572. খেলাখন দুবাৰে হাৰ্দিক পানী তাক যদি মমেণ্টাম বল কৰি থাকিব দিলে হয় খেলাখন ৰখাই দিব পানী খুৱাই কিবা খুৱাই মানুহ নাৰাজ কৰি দিছে 1995 supplementary 1 SCC 572. My lord will kindly come to paragraph 19, 20 and 21. It is true that in Dibakar case and in Venkat Reddy's case, this court upheld the exercise of the power by the government under proviso to clause 3 of the Article 320 of the Constitution. And in Venkat Reddy's case held that temporary employees are appointed in accordance with the rules. As stated earlier, those appointments came to be made during ban period and remained in service for long. In this case, there is no ban on recruitment and appellants were eligible to apply for and seek direct recruitment. In Paripuranam case, another bench of 3 judges considering the similar Madras rule held in paragraph 14 that temporary appointment made under rule 10A so and so to fill in the emergency vacancies were otherwise then in accordance with the rules and temporary service cannot be counted towards seniority. The same is the view held by another 3 judges bench in so and so. In the Dibakar case and Venkat Reddy case, this court approved the validity of exercise of power under proviso to clause 3 of the Article 320 owing to ban on recruitment by the government and long lapse of time which had elapsed from the date of initial temporary appointment till the date of the decision was taken by the government to regularize the service of such temporary appointment. In Vatnagar, this court, while deprecating the practice of the government, giving a go-by to the statutory rules or regulations framed under proviso to Article 309 of the Constitution, making large-scale departure expressed as thus. Then, my lord may kindly come to para 21. This is important. It was reiterated in Keshav Chandra Joshi, and it is a common experience that it is a vicious circle that initially government imposed ban on recruitment and massive ad hoc appointment dehauled the rules, giving go-by to make the recruitment in accordance with the rules, and then resort to regularization of such appointment in exercise of the power under Article 323 proviso or Article 166 to make them members of the service. This practice not only violates the mandate of Article 1416, but also denies to all eligible candidates their legitimate right to apply for and stand for selection and get selected. In state of Odisha versus Sukanti Mohapatra and so it was held that appointment made in violation of recruitment rule under Article 14 and 16. Therefore, as stated earlier, the administrative tribunal has rightly expressed unhappiness over the exercise of power by the state government by resorting to proviso to clause 3 of the Article 320 to make a massive departure to make recruitment in accordance with the rules. We agree with so learned counsel for the Public Service Commission candidates that PSC must be made more functional and its efficacy be streamlined, appointing people of eminence, exercise and competence, experience and competence with undoubted integrity to recruit the candidates in accordance with the rules for appointment to the
Where do
post.
you find people of that quality?
No, my lord, here
We'll tell you, Mr.
Process
Chaudhary.
correct.
We'll tell you from personal experience. Earlier Rajasthan High Court used to get the recruit selections of judicial officers through the
Public Service.
PSC. My seniors on the bench, they were the members of the interview boards. And these are words I heard from their own mouth, that the members of the commission, they were prepared with slips in their hand. Do these two, then we'll agree to your proposals. So the state thinks commission is not very efficient. They want efficient people in the engineering services. So they have adopted this measure. What is the prejudice cost to you? Let us know.
No, my lord, when it comes to violation of fundamental right, my lord, prejudice need not be proved.
Just hold on, sir. Are you being prohibited from participating?
No,
Then
no, my lord.
Then
No, my lord, whenever the issue is whether there is violation of right to equality.
understood.
Then
We
my
we
lord,
will
prejudice
we
need
will-
not
we
be
will-
pleaded
we
and
will-
established.
we will come to that issue later. But for the present, we want to know what is the reason for this litigation.
No, reason is very simple, my lord.
Yes.
My lord, how can we trust the government when when they can't trust the, my lord, public service, their own public service commission? How can we trust the government when they entrust the recruitment to some individuals who are not even constitutional authorities?
Okay.
My lord, my humble submission is very simple, my lord.
Yes.
You will kindly appreciate. My lord, even provide power under proviso to Article 323 can be exercised in only administrative accidents. It cannot be exercised in a manner, my lord, to undo a public service commission. This is an authority for that proposition. Yes.
No, we
Here in
understand.
this case, my lord, the facts were totally different. Where my
That
lord
was a
is-
case of ad hoc appointments
Yes,
being made and then
then
regularization being done.
That
So
is
there-
not-
there-
that
this
not
is
the facts here.
No parity to the
It-
present
it-
case.
it is not of that magnitude as the facts were in these cases, but I have relied on this authority for the proposition, my lord. What are the guidelines what to be followed when you dispense with consultation with Public Service Commission? Here, my lord, some guidelines is there when it says Honorable Supreme Court accepted the contention of Mr. Guru Raja Rao. Counsel for the candidate, PSC must be made more functional and its efficacy be streamlined, appointing people of evidence. Yes, at one point of time, my lord, Assam Public Service Commission had a very black chapter.
By a judicial pronouncement, Honorable the Supreme Court has directed all high courts to conduct the recruitments of judicial officers
Themselves.
in-house. Is that an answer to your
No, my lord.
your argument,
What
please?
I'm saying is, my lord. Yes, no, my lord. I think it would be, no, my lord. In my humble submission, subject to what your lordship may say.
And from our experience, people are not even happy with the High Court making the recruitments. There was a strike in Rajasthan that you selected only 4 against 45.
No, my lord. There will be both sides in every sphere, my lord.
Yes.
It is part of the system. We have to live with that, my lord.
Yes.
In spite of that, our efforts should be to get the best out of what is possible.
Right.
Now, here in this case, when the certain function under the Constitution has been entrusted to the minor
We understand that.
Public
We
Service
understand.
Commission, can
All right,
state-
come with the judgment which
Yes.
straight off
Yes, I'm coming.
goes to the root of the matter.
Yes. Yes. My lord, I'll now rely upon my lord, 2008, 3 SCC 148. Paragraph 71, 72, 77, and 78. Now here also, my lord, Supreme Court permitted dispensing. Kindly see the circumstance. My lord will kindly come to page 165. Para 71 for the facts. It was also observed that cabinet had taken the decision to take out 97 posts from the purview of the commission, which was communicated to the commissioner of sales tax by letter dated so and so. Further, considering the effect of Article 163 of the Constitution, High Court also held that governor was required to act on the aid and advice of the Council of Ministers, headed by Chief Minister, and that the decision of the cabinet had to be accepted by the governor. The High Court ultimately held that the said 97 post of trade tax officer, grade 2, had been taken out of the purview of the commission by the state government on the basis of the decision of the cabinet, and that though the commission did not concur with the decision of the cabinet, the state government fulfilled its obligation of consulting the commission on the issue before taking a decision in the matter. So these are the factual practice. Now please come to para 77. It is clear that proviso to Article 3, clause 3 of Article 320 of the Constitution empowers governor of a state to withdraw from the purview of the Public Service Commission, post in connection with the affairs of the state, and make regulations in support thereof. So under which power, my lord? Under proviso to Article, not under proviso to Article 309. In the instant case, as has been indicated in detail by the High Court, the state government took the steps to withdraw 97 posts from the purview of the Public Service Commission after the said commission expressed its inability to fill up the vacancies in a short span of time because of various reasons indicated by it, such as a shortage of staff and malfunctioning of the obsolete machinery and equipment. It is in such circumstance, and also on account of the fact that collection of revenue was being seriously hampered, the state government in its cabinet ultimately took the decision to withdraw the 97 posts from the purview of the Public Service Commission and to have them filled up on the basis of the limited departmental examination. My lord, my humble understanding is, my lord, state government in exercise of power under proviso to Article 309 cannot just take away the power of Public Service Commission as has been done in this case and also in some other spheres of recruitment, my lord. Question is, yes, in case of some administrative exigency, in case of some other situation, my lord, where the Public Service Commission itself expresses its inability to, my lord, undertake any recruitment, in those situations, my lord, the governor, that too by invoking power under proviso to Article 320.
Not under 309.
Not under proviso 309.
All right.
So, my lord,
Power
this
is exercised by the governor in both constitutional provisions.
yes. So, my lord, 309 couldn't happen because it is subject to 3020.
Subservient to
So, my lord,
309.
I think this is a clear-cut authority for the proposition. If any power exists, it is under proviso. My lord, another judgment, my lord, of course, this is a very settled proposition, my lord, that D.M. Nagarajan's case, my lord, 1979, 4 SCC 507. Where, my lord, a 309 power cannot be exercised to override, my lord, any rules framed under, my lord, statute, or now we are pitted against a 309 to override a constitutional mandate. The Lordship would kindly come to para 25, my lord, at page 514. Apart from repelling the contention that regularization connotes permanence, these observations furnish the second reason for rejection of the argument advanced on behalf of the promotees. That reason is that where rules framed under Article 309 of the Constitution are in force, no regularization is permissible in exercise of the executive power of the government under Article 162 thereof in contravention of the rules. The regularization order was made long after the provision rules, the seniority rules, and recruitment rules were promulgated, and could not therefore direct something which should do violence to any provisions thereof. Regularization in the present case, if it meant permanence, operative from 1st of November 56, would have the effect of giving seniority to the promotee over the direct recruits, who in absence of the regularization would rank senior to the former because of the seniority rules, read with the probationary rules, and may in consequence also confer on the promotees a right of priority in the matter of sharing the quota under the recruitment rules. In other words, regularization order in the coloring the appointment of the promotees as assistant engineer with permanence would run counter to the rules framed under Article 309 of the Constitution of India. What could not be done under the three sets of rules as they stood would thus be achieved by an executive fiat. Now this line, as such, a course is not permissible because an act done in exercise of executive power of the government, as already stated, cannot override rules framed under 309. Now, my lord, here I'm pressing the judgment for the simple proposition, my lord. 162 power cannot be invoked even to override a subordinate legislation like rules framed under Article 309. Now, here there is a constitutional mandate. That means a constituent law. So, my lord, the constituent law can be interfered by the parliament, not even in exercise of its ordinary legislative power. It can only be done under exercise of constituent power under 368. Right. So that being the position, my lord, my humble submission is the regulation cannot withstand the test of.
Have you gone through the Supreme Court judgment wherein the power of recruitment was taken away from the commissions and was assigned to the high courts? What was the reasoning in that judgment?
No, my lord, that was a specific, case in the case of judiciary.
So ultimately, it's the same test. Power of recruitment is with the commission, in consultation with the commission. Article 324.
No, my lord. The expression consultation, meaning over that, there is no dispute, or what is
So
the
then
contour of that?
what was the scheme of things
Uh.
wherein Honorable Supreme Court gave those directions?
No, my lord, yes, in case of judiciary, it has been given. But whether in case of other branch of recruitment, whether that could be done.
All right. Okay, okay, very well.
Anyway, my lord. I think, my lord, 234 of the Constitution,
Yes,
it carves out an exception. Kindly have the Constitution, my lord.
let's see.
Appointment of persons other than district judge to the judicial service of a state shall be made by the governor of the state in accordance with rules made by him in that behalf after consultation with the State Public Service Commission and with the High Court exercising jurisdiction
Yes.
in relation to such state.
So with the High Court, that was the scheme. Commission sat wherein one of the Honorable High Court judges would be the member of the interview board. So the recruitment examination was conducted by the commission. Interviews were held in the commission.
No, my lord, what?
Specific power given
No, my
in
lord.
in relation to a service
No, my lord.
to the commission.
If your lordship would kindly have a look, difference between 234 and 320, my lord. Let me see.
Yes. 234, that way is a stronger provision, which clearly says that it has to be in consultation with the State Public Service Commission. Same with 233. No, 233, there is no rule of the commission, role of the commission.
Yes.
234, the commission is there,
Yes.
which has been now diluted by a judicial pronouncement.
Now, my lord, 233 and 234.
Mazhar Malik ka judgment.
These are specific provision,
Mazhar Malik. Yes.
specific provision in connection with district judges and my lord. I mean, other members of
233
the
is district judges, 234 is the provisions,
subordinate judiciary, other than district.
other than
Yes.
district judges. So for that, the consultation with State Public Service Commission
Now,
is
my lord, will
mandated by the provision.
kindly come to 235.
Yes.
Control over subordinate courts.
That is
Control over
power of
dis-
supervision.
So therefore, my lord, now similar provision doesn't exist in case of
No,
executive.
this is administrative powers of the High Court
Yes,
over the subordinate court.
Yes.
That is a different thing.
yes, yes.
But recruitment is clearly the task assigned to the Public Service Commission by the constitutional scheme.
Yes.
And that has been diluted.
No, my lord. As far as recruitment and condition of service of persons serving under union or the state, the power flows from 309. Ideally, my lord, there should be an act of the legislature. It is only in absence of a, my lord, act of the legislature,
Yes.
by invoking the proviso, my lord, rules can be given, that too for a period till such time act doesn't come into.
Yes.
Now here rules has been framed. The rules denotes a particular procedure, that's a rules of 81. Now that speaks of consultation with the commission.
Then there has
Now,
been
now
amendment.
that has
The
been.
rules have also been amended.
No, my lord, my.
Commission has been replaced by board.
No, my lord, my only submission is for a
Yes.
lordship's kind consideration is the manner in which the present exercise.
We understand your argument is that 309 is subservient to 320 and thus any rules made under 309 cannot override the constitutional scheme under 320.
That is one.
Only if it is to be done, then under proviso to 320.
And alternative, and secondly, my lord, my alternative prayer would be, my lord, can the state just take away the role of, my lord?
Commission in this manner.
I can appreciate in a particular exigency,
Yes.
there is a requirement where the power under proviso to 320 can be invoked. But can it be done in the manner as has been done, where systematically, my lord, the role of, my lord, Public Service Commission is sought to be diluted?
Very well. Okay.
That's my humble submission, my lord. Like, it would
The same logic would apply to
like, it will have- My lord,
same logic would apply to tribunals.
no, tribunals are creation of a central statute, my lord.
Yes, understood, sir. But the tribunals have taken away the jurisdiction of High Court systematically.
No, but
So
then,
we
my
have-
lord,
We have come to accept that.
but then, no, Sampat Kumar judgment has been overruled in, my lord, Chandra Kumar,
Yes.
where the tribunal continues to be only the court of first instance.
Yes,
The
that's true.
division bench, it will come.
That's
because-
appellate
because
jurisdiction is there.
226 is the inviolable basic
226 is
structure.
there, but well, the jurisdiction which was earlier vested in the High Court,
Yes.
that has been taken away.
Partial,
All those, yes,
partial.
partially. Very well.
But my lord, it has been restored in a sense by Chandra Kumar.
Yes,
judgment.
that's true.
So therefore, my lord, in this case, my only submission is, my lord, the institution called Public Service Commission, it is the duty of the state to make it more, vibrant, my lord, more functional, then to take away the service. And my lord, end of the day, my lord, it's not that, my lord, this board is also doing an exceptional job. We all know, my lord. Now, ultimately, who appoints the board members? The political executive.
Right.
Then where is the, my lord, guideline to who will be, the member of the selection committee? At least Public Service Commission has an sanctity. But end of the day, lordship will kindly balance the, my lord,
Who is the
equity.
who appoints the chairperson of the PSC? Who appoints the chairperson of the
Of course. But then, my lord, there is
the
some,
members?
but there is some sanctity, my lord. Anyway, this is my simple case, my lord.
Very well. Okay.
And one important thing, my lord, it's not that state is not aware of its obligation. If your lordship will kindly have this Assam Public Service Commission, my lord, 1951 regulation, if your lordship holding this book, please come to my lord, page 91.
Yes.
Is
91.
Kindly see, my lord, in exercise of the power conferred by provision of clause 3 of Article 320 and in supersession of all previous orders on the subject, Governor of Assam is pleased to make the following regulation as respects services and posts in connection with the affairs of the state, specifying matters in which it shall be necessary for the Assam Public Service Commission to be consulted. So not 309, my lord, they have done it under proviso to Article 320. So they are conscious of the requirement. So when it comes to, my lord,
What are the services which have been covered under this these regulations?
my lord will kindly see, they shall all appointing.
As per the schedule.
Yes.
So you mean to say that they could have just included the engineering services in the schedule?
Exactly. So there is a way out, my lord. It's not that. So, my lord, prima facie, therefore, the regulation as it stands, my lord, it cannot withstand judicial scrutiny. That's my humble submission.
So basically, what I understand is that lordship, while exercising the power under 309, and if we touch any other provisions of the Constitution, we have to make refer to that provision also.
320.
323. While the first rule was made in 1981, we have said that we are having the recruitment through the boards of a Public Service Commission.
Through the?
Through the Public Service Commission.
Yes.
So 81. That was a rule under 309. Whether we mentioned 320 in that rule.
When the original rules were
Original was there.
Let's see, where are the rules?
Original is not annexed, but I have it. I have a copy.
It's in the book.
It is in the book.
Services manual.
Assam Technical Education Service Rules 1981, page 71, if lordship is taking the same book.
Yes, yes.
It is not necessary to quote every provisions of the Constitution while
No, no,
exercising a
just-
power.
Rule page 70.
741, if lordship is having the same book.
No. I think the other book. I'm sorry, my lord, in this book. Not in the
Education manual.
Recruitment. Direct recruitment.
741. Technical education. Yes. Service rules. So these are rules framed
Yes,
under Article 309.
309.
And herein you have made the amendment whereby the
309.
the
We have
commission has
amended
been
this,
commission has been replaced by board.
replaced by the board.
All right.
So
These
when
are the
we
original
made
rules.
this
Where was the method of recruitment?
matter of recruitment.
Made
starts
made
from-
by the commissions.
Yes.
Yes.
That six and
Rule six.
definition is that 2C, commission means Assam Public Service Commission.
Yes. Okay.
And direct recruitment rule 6.
So
Here,
this was
rule
this was
6(3). So every provision
These-
need not be quoted.
That's all right. See, these rules are service rules, wherein you have also made a mention about what would be the procedure of selection?
Yes.
With the commission in terms of Article 320
320.
being the selection authority.
Absolutely, Lordship. Now, whether we can do it or not, whether the situation is there or not.
Ah,
For
for
that,
that
I would
you-
like to place my affidavit. What
Very
are the
good.
ground realities?
Yes, you just let us.
Lordship will kindly take my
Now,
affidavit.
the simple question which we require an answer is, why couldn't you have resorted to 320 subclause 3 for doing this exercise? What prevented you from doing that?
No, it is not necessary at all. If
All right.
required, we can go raid with 323. That is the only thing. Non-quoting of a particular provisions of law is not necessary, and that will not
This is
make
not
the
a
law.
provision of law. This is a constitutional provision.
This is a
This is not a simple provision of law.
the law is. I'll place the Supreme Court judgments on that.
Yes.
So, paragraph 13
Of
of my affidavit
page number.
will be 111.
Yes.
With regard to the statement made in so and so, the deponent does not admit anything which is contrary or inconsistent with the record. It is denied that constituting ASERB board
The horse.
the power of APSC for the recruitment process on the technical side has been taken away by the law. It is further denied that only the APSC is competent and authorized to make recruitment and not the board. In reply to the deponent begs to state that the proviso to Article 309 empowers the governor of a state to make rules regulating the recruitment of services and posts in connection with the affairs of the state. Accordingly, in exercise of power conferred by the proviso to Article 309 of the Constitution of India, the government of Assam by notification dated 23/6/2021 has constituted the Assam Engineering Service Recruitment Boards.
This is all. Mr.
The grounds are also there. This paragraph is important, whole paragraph. If
This
you
is
want, I can.
how
go
it
to
has
the few
been done.
lines.
This is how it has been done. Question
has
is
been
why
done.
it has been done.
I'm going, Lordship, 2-3
Yes.
paragraphs I have to place.
Yes, you place those paragraphs. This is just the sequence in which the things have taken place.
Then I'll go to the facts.
Yes, come.
Lordship will kindly come to paragraph 15.
Yes.
So I'm skipping which are not required. I'll
Yes.
read each, if it's a pieces and big set.
Yes.
From the formation of Assam Engineering Recruitment Board to the key categories of posts like faculties of the Government Engineering College.
Before the formation. You're reading bottom 2 lines of paragraph 15.
I am reading, Lordship, paragraph 15, subpara 1.
Yes.
Before the formation of Assam Engineering Service Recruitment Board, recruitment to the key categories of posts like the faculties of the Government Engineering College and polytechnics under the Assam Higher Education Technical Department were done through the selection process conducted by Assam Public Service Commission. However, certain problems have been faced by the department while recruiting faculty and other technical persons in the government engineering colleges and polytechnics through the selection process of Assam Public Service Commission. It is experienced that the recruitment through the selected process conducted by APSC takes unduly long time. Such delay has badly hampered the recruitment of faculties in the entry-level post in both engineering college and polytechnics under the Higher Education Technical Department. As a result, the gap between the required faculty to students ratio has increased over the years, which has adversely affected the smooth functioning of the state technical institution. Slow pace of recruitment through APSC has led to impediments in establishing new state polytechnics and engineering colleges where faculties are the prime movers. Since year 2017, 3 new engineering colleges and 16 new polytechnics have been established in the state. However, no permanent faculty at the entry level could have been recruited in this newly established engineering college and polytechnic since 2017. This is our position. So far. However, running the institution with temporary faculty is extremely difficult. These repetitions are temporary recruits. And is becoming a matter of credibility of the technical education system in spite of mobilization of huge public resources. Under the above circumstances, it was considered expedient to explore the possibility of establishing an alternative body with the responsibility of selecting candidates for recruitment of faculty and other staffs in the technical institution in a time-bound manner and on a fast-track basis. It has been considered prudent to have a dedicated, specialized body to recruit technical education professionals, much in the interest of public service. Therefore, on analysis and taking the cue on such possibility, The Assam Engineering Service Recruitment Board, which has been duly constituted solely for the purpose of recruitment of technical personnel from the government polytechnics and engineering college under the Assam Higher Education Technical Department. The AESRB has been constituted in exercise of power conferred under 309 and in pursuance of the decision of the Cabinet notification dated 23/6/2021. It is an autonomous body under Higher Education Technical Department. The basic objective of the constitution of the Assam Engineering Recruitment Board is to select candidates to be appointed to the post of faculty and other technical category of post in government engineering college and polytechnics in an expeditious manner, which were previously recruited through the selection process conducted by the Assam Public Service Commission. To make the Assam Engineering Service Board recruitment operational in respect of categories of posts which were otherwise within the purview of APSC, suitable amendment to the Assam Technical Education Service Rules 1981 has been made and is enacted as the Assam Technical Education Amendment Rules 2022 by government notification dated 31/5/2022. Through the said amendment, the Assam Technical Education Service Rules, the recruitment to the specific categories of post in state polytechnics and engineering colleges have been excluded from the purview of APSC. This is number one. And also I'll give the figures how the number of institutions have increased in last 4 or 5 years. Paragraph 15. Paragraph 15, the first paragraph. The deponent begs to state that presently the number of government engineering college has been increased to 2 to 7. Likewise, number of polytechnics has been increased from 10 to 26. More engineering colleges and polytechnics are under process of establishment in the state of Assam in the years to come. This is a daunting challenge in all perspectives, from the resources requirement of quality assurance in the technical institute under the strict regulatory norms of AICTE, NBA, Washington Accord, etc. So our basic requirement is, Lordship, huge, and because of non being able to.
Yes, Saikya, we have read your affidavit. You say why, how it was done, what the procedure will do, how many are the number of recruitments. Does your affidavit say a word? When was the last requisition sent to the board, to the APSC?
Last requisition.
Yes, and it failed. It took so long. Does your affidavit narrate that?
We have.
You are trying to justify your steps.
Yes, Lordship.
So tell us.
So further information needs, then I have to file an additional affidavit. But this affidavit.
This is the precise ground of challenge, sir, regarding
Lordship,
the competence.
whether we have the power or not. That is
Yes,
the core
so come
issue.
to
The
that.
Power is
Come
given
to
under the
that.
Constitution.
This is your justification.
Our
Why you have done.
justification. If
Power.
Lordship wants further information for
So
satisfy
you
our
were reading it.
justification.
You were reading it. That is why the query. Otherwise, the argument is very simple. You are not competent to do that.
No, we are competent to do
So
that.
argue on that.
We are competent to do that.
So argue on that, sir.
Yes, Lordship.
Yes, all right. Come to the
But
argument.
before placing the law, the facts needs to be placed.
So
This
facts
is
are
what I have
incomplete.
learned in my
With due
practice.
respect, the facts are incomplete. The situation wherein you can bypass the APSCs only when you find that the APSC is not able to do the job.
Yes, Lord.
Firstly, where is that
What we
resolution?
have seen from 2017, the
Yes.
hard fact is we are in 2023 now. 6 years down the line, we are not being able to have regular.
Mr. Saikya, when did you make the last requisition? Is your affidavit speaking about that?
We are not, we have
Then-
not given that. If Lordship wants that, because that
No,
was
we don't
in our-
need it.
in our wisdom,
That-
that was not necessary.
All
If
right,
Lordship-
so then come to the justification.
No,
part.
if Lordship wants that, we can give
We
that
don't
figure.
want anything. That is your decision. That
Our
you
decision.
You feel that the APSC was not competent.
No, APSA is overburdened.
Your affidavit is silent regarding that. But anyhow,
No.
now come to competence.
One thing is very clear. From
Yes.
2017, Lordship will kindly come to next page, last 4 lines.
Yes, please.
However, no permanent faculty at the entry level could have been recruited in this newly established engineering college and polytechnic since 2017.
Why?
Yes, Lord.
You have put the affidavit. It is incomplete on the face of it.
Yes, because if we know what was going on in APSC.
Mr. Saikya, then you have to bring it on record, please.
Yes, then Lordship will kindly give me 2 weeks time. I'll file the detail affidavit. What happened prior to 2017 in APSC? Because this is in the common knowledge. What happened in APSC if
It may
Only
be,
last month, the APSC chairman who was in jail for last 6.5 years. All the APSC board members were
Mr.
behind jail.
Saikya, then you junk the entire institution. Can you do that?
No,
It's a constitutional body after
it
all.
is a constitutional body.
There is a flaw in selecting the person
There-
to head
there
the
are-
commission.
there are
That's a
PILs.
different thing.
There are PILs and there are directions from these division bands that we have to do enquiry of all recruitments of 2013 to
We
2017
understand.
by APSC.
That,
That
we-
facts
what
I'll
we
place.
miss, Ms. Saikya.
That
These
will be
facts are not there on your affidavit. please.
Yes, Lordship. Kindly give me 2 weeks' time. I'll file the detailed affidavit regarding the activities and functioning of APSC from 2010 to
And
2017.
please also justify in your affidavit why 320 subclause 3 was not resorted to.
It is resorted, Lordship. I'll argue on that.
So you argue on the, otherwise, if you are able to satisfy us on that, then we don't need to go to
The
that part.
power is there.
Let us
Suppose
see what, by what
Power is there.
what mode you exercise that power. Let us know.
Power is in the proviso of 323 proviso.
Read please.
Yes, Lordship. The power is there. If non-court.
Power under, that is what they are saying.
That
You
is
could
their
have
saying.
exercised.
So while we are involving APSC, then we should have quoted 309 read with 320 in the 81 rules. This is their argument. We cannot. And from where, which source we have taken that, we have to give the schedule entry number also. If we have to accept their argument. All the provisions of the Constitution will have to.
They have
a law
addressed
can
the
be-
arguments to the court.
A
Mr.
law can be set aside, it can become ultra virus only when there is a fundamental violation.
Yes,
And
that
it
is what their argument
unconstitutional.
is.
Now, when the provider itself permits, may I read it, Lordship?
Mr. Saikya, had you exercised this power under the proviso to
The power
320,
is-
there was no question of challenge. You have done it in 309. That is what their argument is.
Yes,
You
Lordship.
can't do it because it begins with a non-obstante clause, subject to other provisions in Constitution.
Lordship, that is a that cannot be fatal. We can only say read with Article 320 proviso so and so. That is the simple thing. If that can be done in that is a flaw.
A.K.
which can
Roy,
be
a
rectified any
thing
moment.
which is required to be done in a particular manner has to be done in that
Yes.
manner alone.
No, the argument will be contra, Lordship,
Very
because 1981 rule says that it has to be done through APSC, through the commission. And what is the provision of in the Constitution regarding that particular provision? That particular provision is 320.
So you are concluding the arguments?
No, I'll place the additional affidavit because those facts will be required. 2 weeks time may be given. That is my prayer. Lordship may give whatever time Lordship is.
Current Advocate General, after addressing the court for some time, Current Advocate General submits that he needs to bring some more facts on record through an affidavit so as to justify the decision of the state government in divesting the APSC from the jurisdiction of making recruitments to the technical education engineering services and Assam student services list on. The affidavit will be filed within next 10 days, re-notify on 16th June. Deeply obliged.
Item number 20.
Yes, please.
Lordship, I'll take your Lordships.
Hmm.
To the background of the initial.
We need not go to the background. First, come to the judgment and more particularly the page 18 of the judgment.
Page
18.
18, Lordship.
Yes, madam.
Yes.
Or rather come to page 21. What more remains? That
Yes,
is the
Lordship.
division bench judgment of 2011.
Lordship.
Since the entire process has been caused, appointment of the petitioner obviously can't be made. What remains thereafter?
Lordship. See?
Read page 21, please, of the judgment.
11 judgment, Lordship.
The judgment which you have challenged in this writ appeal,
Yes, Lordship.
read page 21, please.
Right, President. Yes, Lordship.
Read.
The-
The impugned judgment which is challenged in this
I entirely,
writ appeal.
yes, Lordship.
Are you having a copy?
Yes, yes, Lordship.
So come to page 21.
560. My pagings are marked in 561.
Internal page 21 of the judgment. Para 19,
Yes, Lordship.
para 17 rather.
Lordship.
Yes,
Under these circumstances, it appears
yes.
that the direction has not yet been fully complied, subject to what the respondents may say in the affidavit that should be filed by them. With regard to appointment of petitioner Julogy subject, it is stated by learned counsel for the respondents that the entire process selection was completely vitiated and it has been quashed. As mentioned in paragraph 3 of the affidavit dated 9th August 2011, Lordship.
Next, the
Since the
conclusion of
entire
the-
process has been quashed, the appointment of the petitioner obviously cannot be made.
Yes,
Lordship, what happens here after quashing of this, all those writ petitions, they come, those quashing.
yes, they've got a stay.
No, they have also been reinstated.
Yes, on the basis of orders of the court.
Lordship,
Then
Lordship.
how does that give you a right? You are never in the merit. You are at 47.
Yes,
You otherwise also had no right.
Lordship.
The state says we have caused it. Court interferes and
But-
appoints the persons who are higher to you in merit.
But Lordship, the manner in which show causes were issued, Lordship, they have done it. They have done it intentionally, Lordship. They knew.
Yes,
Lordship, it cannot be like that. But once our order is passed, Lordship, it has to be done with total.
that can be
Lordship.
taken care of in a contempt, not
Lordship,
in the
already
writ petition.
Yes, contempt also we have filed.
All
Lordship.
right, you keep on pursuing the contempt proceedings.
No, Lordship, it has been closed. That's saying that order has been complied with.
Very well.
Lordship,
Then-
then I'll just take Lordship to one judgment, Lordship. Before
Yes.
that, Lordship, I'll satisfy here. Lordship, then this illegal appointees are still enjoying their under services, Lordship.
Hmm.
If they would have called, lawfully, they have been asked to show, they would have show cause them, Lordship, they would have gone. At this time, the others who are in the merit list would not have come, Lordship, because they're already employed somewhere else. My chance to come, how will I get a chance to come when they're not doing it lawfully, Lordship? Only because they put a show cause notice, they call somebody through telephone. They came and then office staff takes the interview and they quashed it. Obviously, they
Yes.
come before this court, Lordship. They challenge the same.
Come to conclusions of the learned single judge in para 20. Read that.
Insofar as first relief prayed for, namely to issue fresh show cause notice by inducting respondent 4 to respond to 16 in service concerned, as already noticed, the division bench of this court in the common order dated 11/8/11 had already decided that the first direction was complied with, and as much as the services of 20 Sulodi subject teachers, including the private teachers herein, were terminated. That it was another matter that some of the persons terminated had approached the court and had obtained an interim order, and that insofar as the respondents were concerned, necessary action had been taken pursuant to the order of the court. But this order of the court was not given a legitimate end, Lordship. It was half-heartedly given those show cause notices. So I am in this petition, Lordship, with my writ petition I came, they would issue show cause notices again on them, Lordship, and there's no bar on it, Lordship.
Yes, okay, very well. Yes, carry on, carry on.
Lordship, when show cause notices were issued to them over telephone, there was no show cause notice also issued. Only over telephone, they have called the illegal appointees, come to the office at this time and tell us how you were appointed. So they obviously came,
Those notices are subject matter of another writ petition.
yes, which was not in the knowledge of the petitioner at that time.
All right, so go ahead and get impleaded in those writ petitions.
But Lordship, there's an order of this, of the apex court, Lordship.
Will you continue with this
Lordship,
conclusion?
one Lordship, 2007 SCC,
Yes,
689, Lordship.
yes, please.
In this case, a similar situation arose, Lordship, writ petition filed, an order was given. The order was challenged by the respondents, appeal dismissed, SLP dismissed. Again, then contempt was dismissed regarding the writ petition. And then they again come before this honorable court with a new writ petition. It's Lordship. The operative portion, Lordship 690. Shall I read the entire order, Lordship?
Yes.
The respondent here was an employee of the Karnataka Housing Board. Here, he was appointed as school second division assistant and was subsequently promoted as first division assistant. On 30/12/1974, a seniority list of the first division assistants was published. The respondent challenged the said seniority list by filing a writ petition before the High Court. The said writ petition was allowed. The single judge of the High Court directed the board to reassign seniority of the respondent herein by placing him above respondent 234 therein and to grant other consequential benefits to him. A writ appeal was filed against the said order, but the same was dismissed. Even the special leave petition filed before the Supreme Court was also dismissed. Thus, the order of the single judge became final. Since the consequential benefits were not extended to the respondent, he filed contempt petitions in respect thereof, but the same were dismissed. The respondent thereafter filed a substantive petition contending that though an order was passed in the earlier writ petition regarding reassignment of his seniority and payment of consequential benefits, arrears of salary to which he was entitled was not paid to him. A prayer was therefore made that the board may be directed to extend monetary benefits as per the judgment rendered in the earlier litigation. The single judge dismissed the writ petition. In writ appeal, the division bench allowed the claim of the respondent herein. Hence, the present appeal. The appellate court contended that the order of the single judge made in the earlier litigation had been complied with, and the board had paid all the consequential benefits to the respondent to which he was entitled in law. It was also submitted that in view of the dismissal of the contempt petitions, it was not open to the respondent to contend that there was non-compliance with the order passed by the court. A fresh petition for such relief was not maintainable. Dismissing the appeal would cause the Supreme Court. Now, Lordship, in page 691, Lordship, Constitution with the Article 226-215. Writ petition for enforcement of directions given in earlier writ petition. Maintainability of effect of dismissal of contempt petitions in respect of non-compliance with directions in earlier writ petition. High Court in earlier writ petition directing the Appellant Housing Board to reassign seniority of the respondent employee and pay him consequential benefits. Said order attaining finality. Board not paying consequential benefits to the respondent. Contempt petitions filed in respect they have dismissed. Thereafter, respondent filing a fresh substantive petition claiming the consequential benefits as per the earlier judgment, considering that despite clear order for payment of the said benefits, the board refused to pay the same, held the respondent had legitimate grievance against the said denial, hence could file the fresh writ petition. Lordship, what happens after the show cause notice? The petitioner went to the office, visited, asked them to do the needful. They did not do. They sat.
You again came to the court. The
Yes.
court refused that prayer of yours, the division bench.
No.
Which ought, no. Read page 23 of the impleadment. Page 23. Cut line. Read the entire page. Thus, in the light of. Second last page of the impleadment.
That's in the light of the.
Thus, in the light of the aforesaid decision of the division bench, it is obvious that this court had already declined to interfere with the reinstatement of the respondent of 4 to respondent number 16 in service after they obtain any. This is a wrong thing given, Lordship. It was not so. The division bench never interfered.
Keep on reading, please.
According to the division bench, necessary action had already been taken pursuant to the said order of this court. In the common order dated 25/1/12, passed by the division bench disposing of both review petition and miscase by the petitioner, it was reiterated that no further order was necessary for compliance with the order of this court dated 6/8/10. As for the second relief claimed in this petition, the division bench, the same common order referring to its earlier order dated 19/12/11 held that the petitioner had to show preferential right to appointment against the available vacancy in terms of the orders dated 6/8/10. And that it had not been shown that any person lower in merit to the petitioner was considered, or that any person higher in merit to her was available for appointment, and no further order was therefore required to be passed in that proceeding. Here, Lordship, during this period, the petitioner was not aware that illegal show cause notices were given.
Please carry on, continue reading, please.
The net effects of both the decisions of the division bench in the common order dated 25/1/12, in my considered view, are that the prayer of the petitioner for enforcement of the order dated 6/8/10, namely which included issuing fresh show cause notices to the respondent 4 to 16 as to why the service should not be terminated after the reinstatement to their services following half-hearted show cause notices issued to them earlier. And further, that the relief claimed by the petitioner for her appointment in terms of the order dated 6/8/10 have been refused time and again. No appeal was preferred by her thereagainst. Consequently, the common order dated 25/1/12 has attained finality and shall now operate as res judicata between the petitioner and the state respondents. This court cannot keep on issuing the same order ad nauseam. I am not, however, oblivious. This is not needed, Lordship. So, Lordship, here
25/1/12, that chapter was closed.
by the
for
single
once.
bench,
Division bench, madam.
but
25/1/12,
yes,
where is the
Lordship.
order?
Yes, 25 by the division bench
Where is
saying
the order, please? Have you placed it on record,
yes, yes.
Mr. Mazumdar? What is the page of
66, man.
366?
Page 364.
Yes. Yes.
I have placed. No.
Yes, 363 onwards. You. Where is the order?
106, Lordship, not 306.
In my copy, it is there, my lord. 366, my lord.
No.
AK Goel.
Yes, yes.
Withdrawal.
106 in my petition, Lordship.
106.
Yes.
Copy given to me, my lord, it is 360.
106.
Oh, thank you.
Shall I read? Lordship?
Yes, please.
106. We have heard Mrs. So-and-so, learned counsel appearing on behalf of the petition person on the issue of further order required to be passed for enforcement of order dated 6/8/10. In order of this case dated 11/8/11, it was noticed that the order dated 6/8/10 stood complied with except for action against so-and-so, for which the state was to file an affidavit. It is now stated by Sri so-and-so that an affidavit in this regard had already been filed stating that action has been taken in terms of order of this court. In view of the above, no further order is necessary for compliance of the order so-and-so. This was the wrong order passed, Lordship. They didn't.
Madam, it had to be challenged then in Supreme Court. It was wrong that it had to be taken to Supreme Court. We can't now review that order. 11 years. So that takes care of your issues. Dismissed.
Item numbers 21 to 24.
Actually, shading very much. Even in our selection, we are doing the impression by yes.
Made prison law. My lord, a short point which is involved in this case is, my lord, the petitioner appellant before lordship, my lord, is a Gaon Panchayat Samavai Samiti. They are asserting their right, my lord, given by this statute to undertake some contract transportation work for distribution of essential commodity. Now, if your lordship would kindly come to my lord, page number 80, my lord. This is the, my lord, order framed by the government of India, my lord. Whereas central government is of the opinion that it is necessary and expedient so to do for maintaining supplies and securing availability and distribution of essential commodity, namely food grain under the targeted public distribution system. Now therefore, in exercise of power conferred under by section 3 of the Essential Commodities Act and in supersession of the earlier order of 2001, my lord, central government hereby makes the following order. Now this is called, my lord, Targeted PDS Control Order 2015. If your lordships will kindly come to 2G, my lord. Authorized agency is defined. Authorized agency means the concerned department of the state government or a body corporate or a company owned by it or a cooperative. Now, my lord will kindly come to page number 82, my lord. Sorry, 83, my lord. 7. Lifting of food grains by the state. The state government shall lift food grains from the designated depot of the corporation through its authorized agency. Then my lord will kindly come to 11, 2, my lord, 11, sorry. State government shall devise suitable mechanism for transportation of food grain from corporation godown to the intermediate godown and door step delivery of the food grain to the fair price shops. 12. State government shall furnish a report on a quarterly basis to the central government regarding doorstep delivery in all format. Then page 84, my lord, rule 8.3, order 8.3. Allocation of food grain made by the central government under targeted public distribution system to the state government shall be used for distribution as per provisions of the Food Security Act and for any other purpose, and not for any other purpose. 3. State government shall ensure through authorized agency physical delivery of food grains to fair price shops by end of the month preceding the allocation month, and in any case not later than first week of the allocation month. So, my lord, this transportation and distribution will be done through authorized agency. That is the statutory banding. Now, my
What
lord,
they are doing it
now they are doing to
auction.
some private agency, my lord,
by auction.
by tender system. of course.
Tender.
So, my lord, Lanet Single Judge did not accept our contention, my lord. Now, as a result, what happened, my lord, the work which we are doing at the rate of 30 rupees per quintal, the government is paying 130 rupees, that to by private agency. Now, my lord will kindly have the.
Was there any notification by virtue whereof they proceeded to procure the transportation?
No, my lord, they issued an NIT, my lord.
NIT
Yes.
directly.
Yes. The NIT, there is no dispute, my lord.
No. Without taking recourse to any other action in accordance with this
Order.
control order, the
Yes.
state of went for the NIT.
Yes. My lord will kindly come to page 62, my lord.
Yes. Yes.
Allotment of so and so of rice under onto the Ojana scheme received from Director of Food and Civil Supplies Consumer Affairs Assam against the month of November 2015 by WT message that is so and so is sub-allotted among LOT as below subject to the condition. Now these were the allotment, my lord.
All right, just before we proceed further,
Yes, my lord.
what mode of transportation does the GSS have available to it?
My lord, hired trucks, my lord.
Hired. Okay. Yes.
Idea is, my lord, we should have also a sense of participation. That's the
Understood.
scheme, my lord.
All right. Okay. So
And at the same time, we thrive, everybody thrive, my lord. Now, when the business as a whole, it goes to the private agency, then it goes to a handful of people, my lord.
an unnecessary competitor is created.
Yes.
Yes. Because you could also have made your bid, put your bid in the process
Yes,
or prevented you from doing that.
yes. And in fact, my lord, if things would have been done through us, it would have been
No,
much.
no, you could have filed your bid in the NIT.
No, it is allowed. bro. It is allowed. They are allowed.
Yes, obviously.
They can participate in the tender.
That's right.
No, my lord, my instruction is, my lord, we are managing the work. We have participated. Now, question is when there is a particular mode prescribed by the authority, why
Well,
are we
let us,
resorting
let,
to all
let us
this?
see, let us see
Yes.
how they have justified and what when single judge has done.
Yes,
Let's see.
the judgment, my lord, it starts at page 104, my lord. The error of parties is also very wrong. My lord will kindly come to page number 161,
Para.
para 18.
Para 23.
Yes.
In light of the facts
the li-
alluded
yes.
above.
In the light of the facts alluded above, let me now deal with the contentious issues involved in this batch of writ petitions. As noted above, petitioners are seeking to enforce a right to handle the transportation of food grain under PDS network to the exclusion of any private operator. It is not in dispute that writ petitioner societies are operating their business as per the privilege license granted under the order of 1982. Section 2A of the order of 82 provides that appointed dealers would mean such category of person, which includes the cooperative society engaged in the business of purchase, sale or storage of sale of any of the notified article, but the same does not include transportation of such article. The order of 82 further makes it apparent that wholesaler, sub-wholesaler, or a retailer would have the right to sell such notified articles at price stipulated by the government. Therefore, it cannot be said that the order of 1982 confers any indefeasible right upon the cooperative society or GPSs to execute. My lord, this was never our case. If it is no doubt true that clause 2G of the order of 15 does not envisage any private party in the matter of lifting of the food grain, but what must be borne in mind is that National Food Security Act of
What is the stand of the central government? Is it a party?
They didn't file affidavit, no? They didn't file affidavit, my lord.
They didn't. Are they party in this appeal?
Yes, yes,
Union of India.
yes, my lord.
Who is there for Union of India?
For the Union of India, the central government.
Because you were coming out on the strength of this,
Precisely, my lord.
which is issued by the Government of India.
Yes,
This control order. What the Government of India has to say about it.
this is very important, my lord.
Call SGA, Deputy SGA, Deputy SGA, Mr. We find that
I think their perspective will be important, my lord.
the petitioners, appellants herein, seek to enforce the provisions contained in the order dated so and so issued by the Government of India, Ministry of Consumer Affairs, Food and Public Distribution, Government of India, insofar as it relates to transportation of food grains under the PDS system is concerned. In this, the Union of India, though party in the writ petition, no affidavit was filed on its behalf. We feel that the stand of the Union of India in these proceedings is essential. Hence, copy of the appeal be provided to the PSGI. Appeal and
We have given copy, we'll give one more, my lord.
we provide appeal and annexures be provided to the PSGI, Mr. RKD Chaudhary, whose name shall henceforth be reflected in the call list. He shall procure instructions and file affidavit on behalf of the Union of India within next 2 weeks. List thereafter. You have to ensure that in all writ appeals, in all 4 writ appeals, copies are provided to Mr. Chaudhary.
My lord.
Item number 25.
Mr. Nath, You also find out there have been similar litigation in the Rajasthan High Court also.
I have the decision.
You have the decision.
Well, not in the Rajasthan High Court, but the Kerala High Court decision I have. In the Kerala High
What
Court,
was decided?
full bench, the same issue. The same issue, it has been decided.
Okay. List on 20th June.
Clause 2G, 7.2 and 7.11 has been interpreted, my lord. And it is the state who is the implementing agency, they can engage the contract.
Same issue.
Same issue.
Hardly anything has been decided. No decision on the issue whether the control order, it clearly reflects, it doesn't indicate involvement of any private agency.
That is the issue, my lord. That
Nothing
that
has
was-
been decided.
That was the challenge and that has been.
What is the issue? Tell us.
But
Read.
no,
Any discussion of the argument?
yes, no?
Read. Read where this contention has been dealt with.
My lord,
Tell us.
I'm coming, my lord.
Yes.
But it was filed by the authorized wholesaler. But para 2, para 3, the issue raised in the writ petitions as well as the writ appeals is whether the state government should or should not be directed to continue with the old system of distribution of food grains under the public distribution system, or to retain, that is to retain the authorized wholesale distributors and to not not to shut them out totally. That is the issue. And here same case, my lord.
The issue is, what is the mode of transportation under the order of 2015? Whether the state can dilute that.
No, well, under that transport. Here, the issue they have raised that the transportation.
Transportation has to be done according with 2G, which does not permit participation by any private agency.
No, I'll make my submission.
Is there any adjudication?
Yes, my lord. 2G, here, my lord.
Read.
Gotcha. Well, at paragraph 5, last page, they have referred to section 2Z.
Paragraph 5 and 7.
2G has been referred. Logic.
What is
Lifting
the
of-
adjudication, please? Tell us. How the Kerala High Court dealt with this issue?
No, ultimately, their contention raised that the transportation we should be allowed and the private party should not be allowed. That
Yes.
has been negative. My lord. That contention has been negative.
How the 2G has been dealt with?
Got it.
The court will say, no, we are not entitled to interfere.
No.
That's an obiter.
7, from a combined reading of the provisions quoted above, 2Z and 7,
Yes.
it would again be abundantly clear that it is the obligation of the state government now to its agency to ensure proper compliance of the provisions of the delivery.
Yes.
So through though certain discretion had been given as contained in subclause 11 of clause 7. It is seen that the scheme of the act and the order in minimal involvement of the private persons. If that be the statutory claim and the statutory policy, there no court can issue any direction contrary thereto and even for a temporary period.
So
Then,
rather the proposition is in favor of the plaintiff's claim.
no, my lord, that is not their case in fact. Lordship, I'll place, my lord, what
That is
they are,
not their case. What do you mean?
well, they say, well, in fact.
No tender, no private agency, only by the agencies mentioned in 2G.
That is what they want to say that as per 2G, only us, not any, no,
Not us. The entities described in 2G.
lordship.
It may be any of them, but not a private player.
No, well, my respectful submission would be, well, I'll place my submission, well, that the state is free to engage its own budget by tender. I'll apply your lot.
20th June.
But
Item number 25.
May it please your lordship. My lord, the issue involved here is selection to the post of principal of a higher secondary school. Now, in substance, annual confidential reports of 3 years, 2013, 14 and 15 were required. I would concede to the fact that 2013 and 14 were wrongly entered. The principal in charge was not the reporting authority because I was not serving under her for a relevant period of time. Now, the inspector of schools, who is a reviewing authority, also could not have written.
Services applicable, there's a कुछ भी नहीं है. Commercialization, all right. Okay. Rajasthan, we are having a dedicated services supply. Any issue related to service, just like that, is with the central government. But is it functional or not? No, that's a different thing, sir. That's a different. Yes.
My lordship. So far as the annual confidential reports of 2013, 14 and 15 are concerned,
Before we proceed further,
my
I
lord,
would like to ask you,
lordship.
is there any administrative tribunal in place to take care of these service disputes of the employees in the state services at par with the CAT? Mr. Mazumdar?
The administrative tribunal is of course there, my lord.
Is it functional?
That I'll have to. But otherwise, my lord,
This would,
there
so
is
far
an
as the
educational tribunal.
2003 rules are concerned, under which the procedure is following, this would give rise to a jurisdiction of the Honorable High Court.
Let's see. Why?
I got the query, madam.
This is a service dispute of an employee in the education services. Why does it come to the High Court then? Why not to the tribunal? You are referring to rules of?
Assam Secondary Education Provincialized Service Rules 2003.
This is.
Under Rule 13 is the procedure for selection.
Just. नहीं.
Education, we will have it in the services.
Services manual. Services.
Education, administrative tribunal regulation, page 40.
Page 14.
Non-government. Non-government education is.
Act 1977. Yes, it's there at page. Page 1 only. So you have the education, the services manual with you,
My lordship.
page 1. Act Assam Administrative
Page 1.
and Pension Tribunal Act 1977. Why will your not dispute not go to this tribunal?
My lord, so far as page 1 is concerned,
Services manual.
No, this is in the, yes, services manual. Read page 1. Conditions of service includes all matters relating to appointment, seniority, confirmation, termination of service and pension matters of a civil servant. So is your client a civil servant or not? Yes. Jurisdiction, save as otherwise expressly provided in the subsection 2. Tribunal shall have jurisdiction to entertain and dispose of appeals preferred by civil servants against any order passed by a competent authority and in any condition of service and pension matters.
I would like to go through it and come back, tomorrow. Let's go through it, because there is a disparity with the education manual, which talks about the tribunal in case of that refers to the disputes leading to teaching and non-teaching staff of non-government institutions. So
non-government education tribunal is a separate matter.
But whether
You are a civil servant.
My lord.
So you are.
I'll have to go through it and come back.
But shall not include. Shall not include. List on Tuesday. If counsel for the petitioner shall satisfy the court as to why the case of the petitioner appellant. Service dispute raised by the petitioner appellant cannot be dealt with the Assam Administrative Tribunal constituted under the Assam Administrative Tribunal Act 1977. List on so and so. Mr. Mazumdar, take your instructions whether the terminal is functional or not. And Government Council shall also apprise the court regarding the status of the commission. Status about functionality of the commission. Or functioning of the commission. List on 6th. This was. We got benches instituted in various places by judicial. Services of all have proper benches, but not the they are functioning. The signature rank officer is there as the chairperson. Even in services. The days on this, the bill is not concerned. Transfer matter to the application of the court. Season of thousands. Thousands. All that I will. Yes.
Item 26.
May I please, your lordship? Last occasion, my learned friend has said that civil suit is pending between the parties. So I have taken the instruction, lordship. Actually, in this matter, lordship, the question is regarding mutation. In spite of earlier there was a pending of civil suit, in spite of pending of the suit, learned settlement was passed the mutation order. There is another action, but now I have got the instruction, lordship, that there is another suit, and against that the RFA is pending in before this honorable court.
So what do you want?
Lordship, my submission is that in this case, the question is regarding mutation.
Yes. So civil suit would not bar your remedy in.
Yes, lordship.
red jurisdiction.
Earlier, lordship, we have pointed out that a civil suit.
So now what do you want? You want to argue the matter?
Lordship may permit, I can.
So you are, why? The matter is listed. Where is the question of us not permitting you to argue?
On the last occasion, lordship.
All right, he made a statement. Now you are saying that it is out of a revenue issue. Revenue
I will argue, lordship.
All right, argue.
My lord, the appellant title suit already dismissed by the trial court, my lord.
Little louder, sir.
Appellant title suit already dismissed by the.
Dismissed, title suit.
Yes.
So mutation,
My lord,
Mr. Counsel, mutation is a fiscal proceeding. It does not confer title.
Right.
So you place the judgment on record. Anyhow, let's see. You have the judgment with you.
My lord,
I have
will
no
produce the
judgment,
judgment on Monday, my lord.
All right. And counsel,
On Monday, lord. I will convince this.
for the respondent submits that the title suit instituted by the appellants has been dismissed by the civil court. The same. The judgment of the civil court be placed on record list after 2 weeks. Hearing for me. Revenue proceedings are stayed. Yes. Precisely. List of 2 weeks. All right. Place it on record.
Item number 27.
There's an adjournment slip is there. Appellant's counsel has circulated an adjournment slip list up to 4 weeks. Yes.
Item 28.
This matter, my lord, my senior is the Lakes in court number 17, my lord. After some time, my lord, he is otherwise prepared, my lord.
Pass.
Obliged, my lord.
Item number 29.
So Lordship, by the last order, I was directed to place on record the settlement between the writ petitioner and the state government, my lord. My lord, may I be permitted to place a letter from the instructing council, my lord?
It's
My lord, saying that there is a settlement, they have not been pressing for regularization, but they were granted the full pay. And they are aggrieved, they are not aggrieved by that, my lord. This was the letter I received yesterday, though no documents have been furnished to me, my lord. The matter is
probably it
from
will
my
be
side.
better that you place the documents on record.
My lord.
And Council Mr. Nayak submits that though he has received the communication from the council regarding settlement between the petitioners and the state government, but the affidavit is also there.
My lord.
Copy of the affidavit is there,
My lord, only of one writ petitioner.
but the document pertaining to settlement has not been provided to him. If place for and is granted, 4 weeks time to place the same on record.
Deeply obliged.
In Nagaland में लाल से क्या obsession? लाल से क्या obsession? Which means लाल is
Item number 30 to 34.
yes.
Milords, these are the batch of habeas corpus petitions, Milords, which deal with the illegal detention of foreign nationals, which was erstwhile till very recently, Milords, being done in the 6 jails across the state, Milords, in 3 central jails and in 4 central jails and 2 district jails. In the
Now they have been shifted.
Yes.
That was this
That
stand
was
of the state.
Yes. On 14th of March, 2023, Milords, in
Yes.
the last order, this is reflected, Milords, of the Honorable Court,
Yes.
that 217 people, as per this court's order, were moved to the center in Madras,
Detention center.
and
Yes.
were being housed in the same premises with people who had been arrested.
They have created separate sections for
Yes.
That has been taken
We-
care of now.
Yes.
As on today, my lord, my respectful submission will be, my lord, there is no live issue in this case, as on today.
We understand that.
My lord, if lordship kindly comes to, they have prayed for setting aside of the 3 notifications at page 36, page 57, kindly come to page 36, my lord.
36.
Lordship.
Milords, in my humble submission, Milords, there are certain antecedent illegalities which I still pray for, Milords. The prayer that it is infractuous, Milords, after I argue, Milords, after I place my case, Milords, if the
Yes,
honorable
no,
bench
no,
is of the
we-
view.
We'll permit you to.
Yes, yes.
Well, by these notifications, the government has, therefore, the governor of Assam is pleased to notify district jail Gwalpara as detention center. Jails were declared as detention center. Those were under challenge. That has been taken care of.
Yes.
As on today, that is not an issue, live issue, Lord. And now, Lord, as per the second, in fact, the third prayer they have made, that
Just
Lordship,
prayer A.
prayer A.
First is detention. Obviously, they are under orders of the competent forum.
Yes, my lord. They are
Yes.
either they are declared foreigner or they are, my lord, convicted foreigners. Lordship.
Notification dated 1/12/2009,
Yes, Lord.
5/4/2010,
10,
and 24/9/2015.
15. Yes, those are notifications by.
Whereby the jails were declared to be the
Jails were
detention
declared.
centers.
Lordship, that has been taken care of.
Okay.
And the second prayer they made, my lord, that. As per
They
as per the
declare their
citizen-
detention to be illegal. That is under the order of the competent authority.
That is under the order of the competent authority and they are released.
So what more issues remain? Now, Mr. Gautam, tell us.
Yes.
Yes.
Milords, the conspectus of this case is this. Since 2009, foreign nationals were being kept in jails, which were declared as temporary detention centers. The issue kept on becoming a live and more live issue because of their acts till recently, Milords, March 2023.
Yes.
The state has acted in deep contempt of orders of the Honorable Supreme Court and this Honorable Court, my lords. In this very case, there was a continuing mandamus of 7th of October 2020, my lords, which was passed, interditing the state to ensure that these people are immediately, forthwith, moved out of these jails, which had been transformed into temporary detention centers, and put in either private accommodations or in government accommodation, my lords. However, my lords, the larger issue at play in this case, in my humble submission, my lords, it goes to the very root, the core of Part 11 of our Constitution, my lords. The union-state relations envisaged therein, my lords. Specifically, Chapter 2 there. The reason is because in 1958, on the last date, my lords, I presented a compilation before this Honorable Court.
Carry on.
Yes.
Yes.
In 1958, my lords, there was a conditional entrustment of power under Article 258(1) of the Constitution, under which, as your lordship may recall, the power under Section 3, subsection 2, clause E of the Foreigners Act of 1946 was delegated or entrusted to the state of Assam to exercise. This entrustment was conditional, my lords. Conditions which were to be imposed by the union government upon the state from time to time. These had to be scrupulously followed. This was the condition of this entrustment, my lords, in 1958. Why this stipulation became important, my lords, is because in 1998, my lords, on 2nd of September 1998, 2nd of July 1998, the central government issued a direction to the state of Assam saying that insofar as convicted foreign nationals are concerned, they ought to be kept in detention centers as a temporary measure so that at the time when they are repatriated into their country of origin, there is a place, there is a convenient place where we can find them. In 2009, my lords, what happened was initially in June 2009, the governor of Assam, acting in consonance with the conditional entrustment of 1958, passes a notification that now it has become incumbent upon us to ensure that the large number of foreign nationals in our state, they are detained in detention centers. My lords, at this point, I would like to bring to the note of this Honorable Court that the power under 3(2)(g) of the Foreigners Act was never delegated, was never entrusted. They do not have the power to detain. They only have the power to restrict movement. Be that as it may, my lords, the governor came out with the notification in June of 2009. In December of 2009, my lords, as my learned senior has pointed out, the first notification comes to be passed at page 36 of writ petition number 2. By this, the district jail in Gwalpara is converted to a temporary detention center. Then comes the next notification of 2012, whereby they again convert 3 more jails into temporary detention centers. And then in 2015, they pass another notification converting another 2 jails into temporary detention centers. The issue now arises because of a judgment of the Honorable Supreme Court. First, my lords, in 2012, the Honorable Supreme Court in Bhim Singh versus Union of India passes directions, my lords, in paragraphs 4 and 5, and the judgment is annexed to my writ petition, my lords. These are all matters of record. The Honorable Supreme Court says that foreign nationals by no means can be kept in jails. They have to be kept outside jail premises. This is followed, my lords, by 3 circulars of 2012, 2014, and 2018, which interdict the state to ensure that by no means are you to keep these foreign nationals in your jails. They have to be kept outside jail premises. Nothing is done, my lords. In fact, they specifically go on and violate this. In 2015, my lords, as I pointed out, after Bhim Singh and after 2 of the notifications of the center, they specifically designate another jail as a temporary detention center. By now, my lords, in my humble submission, they have already moved out of the conditional entrustment. And the consequence, my lords, I will submit. After 2018, my lords, the last nail on the coffin is the central government coming out with the Model Detention Center Manual, my lords. The Model Detention Center Manual is an accumulation, an amalgamation of all of these circulars, of all of everything that has happened since 1958, my lords. The central government says that what we did in 1958 was entrust you the powers. We have provided you, we have sent you these circulars from time to time, from 98, 2012, 14, 18. Now we want to cluster all of this into one manual. Clause 4, my lords, chapter 4 of this manual dealt with the amenities to be provided in detention centers. 4.1 says that detention centers and jails cannot be the same. Detention centers have to be set up outside jails.
Yes.
This is in 2019, Millards. They go to the Supreme Court, Millards, and make concessions before the Honorable Supreme Court that we will abide by the Model Detention Center Manual in letter and spirit, Millards. It's a matter of record. I placed these orders before this Honorable Court. This is in the INRE 1382 prisons case, Millards. On 2 dates. Once they say that we will comply scrupulously with the Model Detention Center Manual. On the second time, they say that we have received rupees 46 crores from the central government for the setting up of a detention center exclusively to house foreign nationals. And once that is set up in the earmarked place in Gwalpara, all of these people, foreign nationals, will be housed in the detention center. It's a matter of record. Thereafter, my lords, in 2020, after all of these concessions were in place, after everything that they had done, which was completely contrary to the position in law, in 2020, these 5 writ petitions came to be filed before this Honorable Court, my lords, during COVID. The issue that was raised was that since 2009, you have been illegally detaining these foreign nationals in jails, which you cannot do, which is totally against the directions which have been issued by the central government in terms of the conditional entrustment of 1958, which in my humble submission, my lords, it amounts to law. Lordships are aware in 1964 itself, the Honorable Supreme Court has held that a conditional entrustment under 258 amounts to a law. They violated the law in the sense that once a conditional entrustment is done, my lords, only till the time that they subscribe to the limitations of the conditional entrustment will the entrustment remain, and their status as the central government under the General Clauses Act of 1897, my lords, will remain. I'll just elaborate a little bit on this, my lords, the General Clauses Act. The General Clauses Act, my lords, section 3, subsection 8, clause B, has a stipulation. It defines central government. General Clauses Act defines central government as the state government under Article 258, as long as it complies with the stipulations which are sent to it because of a conditional entrustment. As long as it functions within the limitations of the conditional entrustment, the state government steps into the shoes of the central government, my lords. However, what happens, my lord, the consequence of a state government stepping outside the shoes, the ramifications of that are very grave, my lords, and that is why, my lords, I humbly submit before this honorable court that the state cannot today, should not today be allowed to take a stand in my humble submission that this matter is infructuous. After acting callously and without any responsibility whatsoever, not for 1 year, 2 years, 3 years, 4 years, my lords, since 2009, they've acted like this. And this honorable court, my lords, in its order of 7th of October 2020, has noted all of this, my lords. This honorable court had directed the state that you need to put these foreign nationals outside the jails immediately. They did this in 2023, my lords. 2023, my lords, 3 years. They have intentionally violated the order of this honorable court, my lords. They have filed status report on status report, affidavit on affidavit, saying that Matia is going to be completed in 2 months, in 3 months, 6 months, 45 days. They've conceded before this honorable court, my lords, in an order of 11th of February 2022, the state said that once Matia is operational, all the grievances of the petitioners are going to be alleviated. Acting directly contrary to this, what they have done, my lords, in February, once Matia was constructed and it was made operational, they converted Matia into a temporary jail, my lords. Acting directly contrary to their own submissions, their concession before this honorable court.
Mr. Gautam.
Yes, madam.
Matia is a facility for 6,000 people.
For 3,000 people.
3,000
Yes.
people. Your detainees are 217 in number.
Yes.
So can we allow that entire facility
Yes.
to be utilized only for 2,217 people?
Indeed, my lords.
They had their regional risk classification. 2 parts they have kept for the prisoners who are again a different section entirely.
Yes.
Not ordinary criminals.
Yes.
There is nothing unreasonable in
My
that.
lords, will kindly see page 105 of writ petition 2, my lords.
Yes.
I'll come directly to
We'll
the point.
continue at 2.
Page 105, my lords.
We'll continue at 2.
At 2, yes. Grateful, my lords.
Deeply obliged.
Both appeal fields are dismissed as being devoid of merit. Appellant Rahul Amin shall comply with the directions given by the Learned Single Judge and convene the meeting within a period of 15 days from today after complying with the requirements of section 15 of the 1994 Act for considering the motion of no contempt. Yes. Yes. Okay.
Please, Milords. Milords, before lunch, Milords, if I may. We say that the question which perhaps.
Has the Union of India responded to your petition?
Milords,
Has the Union of India responded
unfortunately, Milords,
in
they
these
haven't,
proceedings?
they haven't, Milords. They've not filed anything. In fact, all the,
Presence of Mrs. A. Gayan is there. Where is she today?
Lordship, Mrs. Agan, mother-in-law is not well, Lordship.
Madam, the case was taken up. It is being heard. Nobody has the courtesy to make a mention on her behalf. Because the response of Union of India is important in this case. It is stated that Mrs. Agan, the Central Government Council, is facing some personal difficulty today. A request is made to adjourn the matter on her behalf. Re-notify on 18th July.
Milords, it may be.
Now it will not be possible.
Any short date, Milords, in June.
Not possible, Mr. Gautam, now. 18th July. Let
Milords,
it come.
if the union, I may request, Milords, if the union may be asked to bring the reply on record as well.
In the
by them,
meantime, affidavit shall be filed on behalf of the Union of India in these proceedings
with an advance copy, Milords.
with an advance copy to Learned
Great.
Council for the petitioners. कर लीजिए, कर लीजिए, ले लीजिए। ये वापस नहीं। इसका कौन से मैटर में था देखना।
Passover matter, item 5.
There has
Alert
been
the
an inadvertence, my lord. There has been an inadvertence. The result, everybody's result was together, my lord. Everybody's result was taken up together, my lord. There was an inadvertence. It has been kept in abeyance, my lord, on 30th.
All right.
Appointment letter was issued on the 25th. It has been kept in abeyance on the 30th month.
Yesterday,
Day before yesterday, my lord.
day before yesterday. All right. So
Came to
that
us.
appointment order is of no use to you. Argue on merits. That order can't be given effect to. It was supposed to be kept in a seal cover, could not have been declared.
Yes, but it's,
So
their affidavit.
you can't take advantage of that mistake.
Their affidavit is required, my lord. otherwise-
Affidavit,
I'll have to file it, my lord.
in counsel for the petitioner, pointed out that the result of the petitioner was declared by the respondents, and she has been declared successful in the selection process in question. This is indeed a questionable act on part of the respondents, because while granting liberty to the petitioner to participate in the selection process, we had clearly directed that the result of the petitioner shall be kept in a sealed cover and will not be declared without leave of this court. And Mr. Mazumdar submits that the result was declared with the other candidates. Result of the petitioner was declared with the other candidates owing to inadvertence, and now a decision has been taken to keep it in abeyance. The entire process
No,
or
her selection.
her selection of the petitioner in abeyance for the time being. He prays for the authorities concerned are cautioned to remain careful in future. Mr. Mazumdar prays for and is granted 3 weeks time to file affidavit.
Any date, my lord?
List on 17 July.
First over item 28.
This is a appeal preferred against the learned single judge's order, Lordship.
Yes.
Basically, we are aggrieved because it was relating to construction of a godown in Nagaon in terms of an NIT dated 10th of April 2015, where there's very important clauses, Lordship, which Lordship will kindly come to page 66. Those facts will be required, so I will place certain
66.
page 66.
Yes, please.
Page 66, there is a model tender. Next page. Seal tenders are invited to folds for construction of godowns for FCI storage requirement to be managed and supervised by FCI for a guaranteed lease of 10 years in BOT method for total so-and-so capacity. We are concerned about serial number 5, Nagaon,
Nagaon.
50,000 metric ton. That Lordship will kindly take note of, 50,000 metric. Offers for smaller capacity will also be considered in case sufficient offers are not received for the capacities indicated above against any or more locations, subject to the conditions that minimum godown size should be of 5,000 metric ton for plain area and 1,670 MT for hilly areas. Now coming to clause 7 at page 69. I do not have a land of my own, so in 120 days, I have to give the land documents. That is terms of the contract.
Yes.
Serial number 7, the technical bid must be accompanied by EMD at rupees 20,000 rupees per metric ton in the form of demand draft.
Rupees 20 per metric ton.
Rupees 20 per metric ton in the form of demand draft in favor of FCI payable at Guwahati. In case the tenderer does not own land or hold it on registered lease, but intends to acquire the same by way of ownership registered lease within 120 days from the date of acceptance letter, he shall also furnish, in addition to the aforesaid MD, a supplementary guarantee in the form of bank guarantee at rupees 100 per metric ton issued by any nationalized bank and valid for a minimum period of 6 months from the date of submission of tender. So in respect of this, I have submitted 150 lakhs bank guarantee for EMD and another 20 lakhs for the supplementary guarantee. This is the core issue. Whether they have any right to forfeit it or not.
Forfeit it.
Yes.
Okay.
Then Lordship will kindly come to page 74.
So will your arguments at Advocate General on this side be of any help?
No, Lordship, this is totally arbitrary action on the part of FCI.
That was just in the lighter vein.
Yes.
Don't take it so
No,
seriously.
no, I am not taking it.
Yes.
And they have also discriminated me. In Jammu and Kashmir, they follow a different yardstick. In Assam, they follow a different yardstick. In Punjab, Kupwara, they have a different yardstick. In Jharkhand, they have a different yardstick. And when they have themselves decided that we cannot take this decision, refer it to the Delhi level, the high level committee. In that time, they have forfeited it.
Okay.
On the previous day, I have renewed my bank guarantee for another 7-8 months. Whether in that position, they have the right to forfeit it or not.
Forfeiture. Okay. Forfeiture is on account of non-compliance of the tender
Because
condition.
I have failed to submit the documents regarding 120 days. So I requested for extension. They gave a extension as if it looks like 3 months, but when practically it is for 17 days. Then another extension they have given me, that was for 25 days. In total, they have given me 43 days. I'll place all the facts.
Yes.
Whereas in Punjab and other places, they have given for 11 months, 9 months, 7 months. So in my case, that was the case. And on top of that, the state level committee given me the extension up to 7/7/2015. On 6th, I renewed my bank guarantee. On 8th, they have forfeited. In the meeting, they have decided that we cannot give extension beyond 7/7. For that, the high level committee at Delhi will have to take the decision. So they referred the matter on one hand. On the next hand, they have already forfeited my thing.
All right.
And I have invoked the clause of force majeure, whether I have defaulted because of my own negligence or because of certain situations which are beyond my control.
Okay.
So who can apply clause 5? That Roman 4 is the person who does not own, that I have already placed. This is the clause, relevant clause under the NIT. Then Lordship will kindly come to earnest money, clause 6, earnest money so-and-so, that is 50
Reading a
lakhs.
page.
74.
74.
Clause 5(1), who are the eligible persons who can apply? Roman
That you
4,
applied, there's
yes,
no dispute about it.
that earnest
eligibility.
money 50 lakhs and 20 lakhs, 6 and 7, forfeiture. The earnest money shall be liable for forfeiture if the tenderer, after submitting tender, resiles from his offer or modifies the terms and conditions thereof in any manner, being understood that the tender documents have been made available to him and he is being permitted to tender in consideration of his agreement to this stipulation. The earnest money is also liable to be forfeited in the event of tenderer's failure to furnish the requisite security deposit by the due date after the acceptance of his tender without prejudice to any other rights or remedies of the corporation under the contract and laws. 3, in the event of tenderer submitting conditional tender, EMD of such tenderer will be forfeited. The bank guarantee furnished as supplementary guarantee shall be liable to be encased along with forfeiture of EMD on happening of any of the events. So 3 conditions says, resiles from the offer or modifies, fails to furnish security deposit, and the third condition is if I change the conditions of the tender.
Yes.
And refund at next page. Last 4 lines, the bank guarantee furnished as supplementary guarantee by the successful tenderer will be released on production of necessary documents evidencing acquisition of the land specified in the tender by way of ownership within 120 days. So that is regarding the supplementary. Security deposit is there.
There's a refund.
Now kindly
We are not concerned with
yes,
the refund.
on clause 59, page 91. Force majeure. Page 91, Lord.
Yes.
Clause 59. A force majeure means any event or circumstances or combination of events which are beyond the reasonable control of the affected party, which such party could not have prevented or reasonably overcome with exercise of reasonable skill and in care in relation to the implementation of this agreement, which do not result from the negligence of such party or the failure of such party to perform its obligations hereunder, which are of an incapacitating nature and of a severe magnitude and have a material adverse effect on the affected party's obligation under this agreement. A party shall be entitled to suspend or excuse performance of its respective obligations under this agreement to the extent such performance is impeded by force majeure. The learned single just held that because of our negligence, it is rightly forfeited. This is what I have to counter. Procedure is laid down in the clause. So regarding the procedure, I don't think they have any complaint against us. On timely, we have given all the notices. And B, prolonged notice force majeure. In the event force majeure continuously impedes or prevents a party's performance for longer than 60 consecutive days from the date of commencement of such force majeure, withstanding the suspension of the obligations of the parties, they are at liberty to terminate this agreement. So there is no doubt about the meaning of these provisions. Now, after this notice was issued, immediately I have submitted my tender along with the list of lands which I propose to buy. Page 147. This is the bank guarantee. Yes. This is the bank guarantee of 50 lakhs. First one, that is EMD. Then Lordship will kindly come to page 149. Along with my tender, I have submitted this on 28th May 2014. The work order was issued on 9th September. So I have given the list of 21 plots of land.
Yes.
56 bighas, 2 kathas, 4 lessas, or 20 acres in approximately. On affidavit, I have submitted. These are the lands I have proposed to either
Acquire.
lease or buy.
Yes.
Thereafter, on 11/9/2014, this is the work order. Page 150, second paragraph. You are requested to construct 550,000 metric ton capacity of village Oguri Kochumari as per engineering spec, etc. And regarding the FD, earnest money as well as the security deposit, they have requested me to deposit, which I have done accordingly. Page 152 is the additional security of 20 lakhs. This is 10 lakhs and another 10 lakhs was adjusted with the earnest money. So there is no dispute regarding the 70 lakhs, which I have to deposit. As per the terms and conditions of the tender, I have to complete the work of submitting the documents relating to the land by 8th of January 2015.
Yes.
So on 8/10/2014, 153, I made a request to them.
153.
153.
8/10, just a month,
Second
within a
paragraph.
month.
No, because this was because
153.
153,
Yes,
Annexure H.
Yes.
In order to facilitate an early execution of the assigned job and also to pave the way for overcoming the glitches likely to be encountered by us at the site, we would sincerely request you to kindly graciously enough to inform and request all the relevant state departments and authorities concerned to exercise their good offices for removing hurdles in sourcing and approved land for the smooth and early completion of the job, so that the capacity can be created at the earliest to bridge the gap between requirement and availability, ensuring smooth PDS supplies. As
Why
well.
was this the obligation of the corporation?
There is no obligations, but I have requested them also when it is in the name of FCI, that things get easier because central government and it has public interest.
Okay. Very well.
So what I am trying to project is that my intention from very beginning was positive. It is not that I deposit 70 lakhs, participated, and all of a sudden I terminate it out of my own sweet will. It is not that.
Okay. Okay.
So now the first problem came from Krikhok Mukti Hongram Committee, KMSS. This is a farmers organization. They lost their complaint before the deputy commissioner on 30th December. My deadline was 8th of January. Memorandum not to use agricultural land in other purposes. Accept my respect with the Krikhok Mukti Sangram Committee from the very beginning, demanding the Assam government not to hand over agricultural land of the farmers for use of other purposes. Already we have come to know that Food Corporation of India, through a company called Gagandil, the petitioner hearing, is trying since last 5 months to purchase 68 bighas of agricultural land of farmers at village Oguri. But we came to know that the company has already purchased some portion of this land. We Krikhok Mukti since last 5 months have closed the sale purchase of land there. Who are they to close it? But they have stated that we have closed. But the owners of the Miyadi Patta land in this area are also responding to our protest, but are now ready to obstruct the construction of the warehouse in that area. Moreover, in that land, one brick kiln is also causing environment pollution, making unsuitable for warehouse. Therefore, we Krikhak Mukti Sangram Samiti demand construction of the warehouse in some other places instead of that place. Otherwise, we Krikhak Mukti Sangram will have no other options to raise serious agitation against it. This is the first letter from Krikhak Mukti, and a copy was marked to the FCI personnel also. Then another organization, that is Nagaon, All Nagaon District Students Union. That is another powerful organization. They wrote to me, to the director, respectfully inform you that you are hereby asked to stay away from the act of purchasing land that customary moja by persons of your company for construction of warehouse, because presently pollution is already taking place there from the brick kilns. In future, if construction of godown type houses take place, various types of vehicles will regularly start flying there, which will result destruction of academic atmosphere of the village, and keeping in view that you are asked to stay away from such activities. So I get this letter from Nagaon District Students Union. Then third one, All Tiwa Students Union, Nagaon District Committee. Accept our revolutionary greetings. We the all Tiwa students are already come to know that your company is continuing purchase of land at Kasameri area for construction of warehouse. But most regrettably, we inform that already the existing brick kilns have polluted the environment and deteriorated the conditions of the road. Main reason of this is too much of flying of trucks. Now, construction of warehouse type house in this area would destruct the educational environment here, and too much flying of vehicles would affect negatively by destructing the natural, academic, and social system. And keeping that in mind, we call you to stay away from purchasing land for construction of godowns. These are the three organizations. Then physically we are attacked. We lost the FIR. Page 161. Respectfully informed that on last 20/10/2014 at about 10:30, while purchasing land at Kasameri under Roha on behalf of Gogandil, 4 unidentified miscreants misbehaved me, restraining me and my colleagues on the road and threatened to murder. Thereafter, Ejahar is filed, and there's a police report to that effect, page 163. This is to certify that the complainant Orup Chaudhary, so-and-so, lost an Ejahar to effect that on 2010 to at about 1:30, it should be 10:30, at Dimo Sariali. Unknown miscreants wrongfully restrained the complainant misbehaved with slang language with criminal intimidation regarding buying land at Kasamari by the complainant on behalf of Gagandil. Police case number 325 of 14 under section 341, 294, 506, 34 registered. So this situation has stalled my efforts to purchase land and fulfill my commitment of giving the documents to them by 10th of January 2015.
Yes.
On 2nd January, I first give the notice as per the procedure that I am not being able to fulfill it because of these are the reasons, and I am invoking force majeure itself. Second paragraph. Imbibed by strong desire to accomplish a given result, though through a course of action to
We are reading at page.
page 165. On top, the Lordship will kindly take note of the date, 2nd of January 2015.
Yes.
Second paragraph. Imbibed by strong desire to accomplish a given result through a course of action to fulfill and materialize the prospective event to acquire and hold the suitable plot of land on registered lead or outright purchase, we held several rounds of discussion with the prospective lessors, sellers of a suitable plot of land situated at Oguri, Nagaon, to and from 12/5/2014. Unfortunately, of late, it is experienced that some very powerful organizations and representatives claiming to be actively involved in safeguarding the agriculture land rights of the villagers have started fitting spokes in our endeavor and thrown down the spanner into the half-processed deals, besides attempting to physically assault and injure our representatives, including the undersigned, demanding thereby that we should get out of Oguri village, failing which they would be free to indulge in any hesitation to attain their ends by means fair or foul. we are thus in a catch-22 situation, and specifically for the, we had written and submitted our letter dated 8/10/2010. A fortuitous event has now occurred which falls under force majeure clause, and there is no room or space at all to overcome the stalemate, even with the exercise of reasonable skill and care. This development is of incapacitating nature and severe magnitude, which creates material adverse effect on the performance of our obligation. In the face of the above impasse, we would request you to be gracious enough to allow us to change the site of the for accomplishing the objective of the above tender. Reset assured that once you give your assent for change of site in view of the occurrence of the fortuitous event, we shall immediately announce another suitable plot of land for executing the subject work. Inconvenience cost, if any, is highly regretted. Then another letter we have written on 7/1/2015. Here we have basically written the first line, tomorrow 8/1/2015 is the last date fixed by you for that work. And last paragraph, in face of the above clarification and for sake of equity and justice, we request you to kindly order for allowing change of site as paid for, or and do refrain from either taking or imposing any premature punitive measure or steps before arriving at a mutually accepted and effective resolutions and issues highlighting in our preceding letters resting with our letter dated 2/1/2000 as well as the instructions. One thing is very important, Lordship, that till date, I'm sure they could not have that project in place. After certain time, they issued another notice bringing the size of the godown from 50 metric ton, 50,000 to 30,000 metric ton. Even then also, this project till date has not been seen the day of the light of the day. Then another letter of 28/1, I wrote to them requesting all these things, give us extension or give a separate plot of land, and also reiterating this force majeure clause. We received a letter from them. This letter, on our basis of our letter, 25/2/2015, extension of time period for submission of lease land documents up to 31/3/2015. Your letter dated 8/1, received on 16/2. The time period for submission of land documents for Nagaon location has been extended by SLC till 31/3/2015. In view of the above, you are requested to submit the requisite documents within 31/3/2015, failing which FCI is likely to take steps as per the MTF. This letter, Lordship, we have received on 13/3. They issued it on 25/2. In our affidavit, in our paragraph 15 of our petition, we have made a very categorical statement received on 13/3/2015. So to get this letter, we have to wait for another 20 days. So practically 17 days we have got. We did not know our fate from our January's letter. So 17 effective days we got for extension up to 31st. Then thereafter, 18/3, we made another letter at page 172. If Lordship is pleased to look at down below.
Yes.
After we get this letter on 13/3, on 18/3, we wrote a letter requesting them. We write this letter to request you to kindly extend the period of submission of land purchase documents up to 7/7/2015, 7th of July, which was the date originally requested by us in our letter dated 8/1/2015. In January's letter also, we made the same request. Thereafter, we sent another reminder on 28th April, page 173. Here also, our request was up to 7/7/2015.
Yes.
Last two lines, Lordship. And here we have written that only 17 days we have got. Then there was a communication from them, which was the impugned order, 34/2015. So they have invoked various clauses, clause 8, clause 9, etc. Clause 57B. Last two paragraphs I'm reading. after due consideration of all the facts and MPF clauses cited above, it is found that Gagandil Limited is in violation of the terms and conditions of the MPF, and therefore the contract under reference is liable to be terminated. Accordingly, the contract awarded to Gagandil Limited is hereby terminated forthwith, and he shall also liable for risks and cost. Consequently, it is further ordered that security deposit submitted by the tenderer stands forfeited and bank guarantee is be invoked. So 30/4/2015. Thereafter, we made a representation. That lordship will find at 175. 8/5/2015. We reiterated all the grounds on the basis of which we seek to invoke force majeure. These are incorporated here. And lordship will kindly see the persons who are grounds also.
Yes.
Page 177. I am reading clause JKL,
Yes.
small l. For that, had the extension of time originally sought up to 7/7/2015 been granted, then by now, in the face of the deal still going on ahead, hectically and strong, without loss of any time, such occasion for the issue of the termination order in such an illegal manner would not have been propped up. And now we have lost considerable working time waiting in writing in anticipation of the grant of extension up to 7/7/2015. We now desire to make for the lost time, and hence it would be in the fitness of things and in accordance with the tenets of law to seek a further extension up to 7/12/2015 to compensate the lost period, and during which period the product procurement purchase of the land would be completed. And after the final purchase, which has to be preceded by the grant of sale permission by the Office of Deputy Commissioner of Nagaon, we would be in a position to submit the final sale deeds to you by then. So this letter was of 8/May/2015.
Yes.
By this lordship, all this organization, everything, they have reduced their protest. Why, I cannot say before this honorable court, but somehow they have mellowed down and things were progressing. So we made this request that kindly give us time till 7th of December. That by that time we will give. They did not do anything.
Yes.
They had a meeting on 14/5. That minutes lordship will find. The minutes I'll place it. Minutes will be. Some minutes when they come. My submission in details in writing was at page 179, where my prayer is specific. We prayed for till December extension.
Yes.
2 minutes I would like to place before I go further. 1 minute lordship will find at page 237. While they granted me extension up to 31st March, what was their position? What was their stand? Page 236B, Annexure A, have lordship got it? Minutes of the SLC meeting, state level meeting, lordship, held on 28th February at FCI regional office for construction of the godown under PEG. Members of the SLC, that lordship will kindly note down, there are 7-8 persons who are the members of the state level committee. Coming to number 1, construction of 50,000 MT at Nagaon. So in the first, there is a narration of the dates. Coming to the next page, similar cases were reviewed in the 35th HLC meeting held on 24/7/2013. As per minutes of the 35th HLC meeting and corresponding emails, SNC Division FCI Headquarters 1/1/2015, SLC is empowered to take decision for condonation of delay in submission of land documents, so SLC may take a decision on the request of the party. Such extension was earlier given by SLC of Jharkhand region in another PEG case of Kodarma Center. The SLC felt that there was no provision of extension of time for submission of land documents as per contract provision. Once the contract is awarded, FCI authorities should execute the same as per the contract provisions, and the case should not have been referred back to SLC again. The SLC also felt that there is dire need for go downs at Nagaon districts and reasons for not submitting the documents are appeared genuine. So they are convinced that whatever reasons we have cited, they give an opinion that these documents and the reasons for not submitting the documents appear genuine. So they were convinced that the grounds are genuine, authentic, where the learned single just said that these are not authentic without any factual analysis. There is a precedence of granting permission of extension of Kodarma in earlier instance also, documents produced by FCI in the meeting. Moreover, HLC is a high-level committee, the central level committee, has also given direction in the 35th HLC meeting as per minutes produced before the SLC. After deliberation on the subject, although there is remote possibility of submission of documents by the party, SLC agreed to allow FCI authority to extension of terminate timeline of submission of documents up to 31st March. So while they granted me till 31st, they themselves knew that the time is not sufficient at that point of time. Although there is remote possibility of submission of documents by the party, that means they are convinced that I won't be able to do it within 31st March.
Yes.
But they also recorded that the grounds are genuine. SLC agreed to allow FCI authority for extension of timeline for submission of land documents up to 31st March on public interest. It is advised that busy amounts shall be encased by FCI without or before expiry of the validity in case the party fails to hand over the documents within the extended time. These minutes and this decision was sent to us on, we received it on, I think, 13th of March. So 17 days time. This is 1 minute I would like to place. The other minutes, Lordship, I would like to place is at page 243. This is after my representation in the month of May, after the termination order of 38th of April. This is the minutes, Lordship would get at page 242, Annexure J.
Yes.
Minutes of the SLC meeting held on 14th May at FCI regional office for construction of go down under PEG scheme. These are the members present, Lordship. Then first page, that Gagandil's issue, all the narration of the facts. Coming to the next page. SLC called the party for personal appearance to explain the reasons for non-submission of land documents within the time period and also to understand his preparedness for execution of the work. Sri Vinod Agarwal, representative of Gagandil, explained that after award of contract, the owners of the land had been influenced by some powerful organizations for not selling the land to him. Landowners also increased the rate of the land after confirmation of purchase by him. However, so far he is successful in acquiring 12 bigas out of 67 bigas, for which he was able to show documents to SLC. The party also submitted an appeal that the termination may be revoked and extension may be granted up to 7/12/2015. Very categorical, Lordship, they have noted it down. While later dated 6/5/2015. SLC observed that ED&E has no jurisdiction to take decision for not giving extension of time for submission of land document. Only SLC can take a decision in this regard, and so the later dated 8/4/2015 is technically not correct. Condonation of delay for submission of land document in PEG go downs in Kupwara 10 months, that is in Punjab. Udhampur 2 months. Jammu and Kashmir 11 months. Was done by SLC of North Zone in August 2014 due to law and order problems. Full stop. Situation in Assam is also not very different. This is their understanding. So situation in Assam is also not very different. Keeping the difficulties faced by the tenderer for land acquisition and also need for go down in Nagaon district, SLC is of the opinion that the extension for submission of the land documents for the full 67 bigas may be granted up to 7/7/2015 in public interest. However, the extension will be subject to reduction of the period of guarantee in extent of delay. This issue to be put up to SLC for information and ratification. Next line, Lordship, next 2 lines. SLC also decided that if the party fails to submit the land documents within 7/7/2015, the matter may be referred to HLC for consideration of his present request for extension of 7/12/2015. So they take half decision, the remainder decision, they have referred it to the HLC. The communication regarding this meeting, I have received that information on 11th of June. This meeting was of 14th May. That document also I have, Lordship.
Yes.
181. Lordship. Page 181. The date is 10th June. So the meeting held on 14th May. They issued the letter on 10th June. I received it on 12th June.
Yes.
Extension of time period for submission of land lease documents till 7/7/2015. Reference termination of 34, SLC meeting 14/5. SLC has granted extension to your firm for submission of land documents by a majority decision of 7/7/2015. Extension is subject to ratification by HLC and reduction in period of guarantee to the extent of delay. The termination order given effect to have been kept in abeyance up to 7/7/2015 in view of the SLC decision. You are therefore advised to make arrangement for purchase of land deed with the full quantity of 67 bighas as per the award contract within 7/7/2017. However, this does not confer any right upon you make any claim for extension of the aforesaid case as the matter is subject to ratification. This we have received on 6/12. One very important thing which they have not included here is that, Lordship, the minutes. That minute of 14/5, we got it in their affidavit. That they have decided that if I fail to submit the document on 7/7/2015, then the matter will go to the HLC to consider whether I am entitled to get the extension up to 5th of December 2015. That they have disclosed, not disclosed. This is where there is a malafide intention.
Okay.
On this, after this letter, I tried again with them that kindly give me till 15th, I wrote on page 82 on 11/6. I made a request that kindly give it to 7/12. Then another letter of 18/6 after receiving that letter. Again, I made the reiterate my prayer. And my good intention can be assessed from the fact that page 189. If I had anything bad in my mind that I will not do the work, I would not have extended my bank guarantee of 50 lakhs on 6th of July. That is the penultimate date, or the date before 7/7 was to be expired. Lordship will kindly take note of the date. Date 6 July 2015. Here, the bank guarantee so-and-so of 28 May 2014 for 50. It has been extended up to new expiry date, last line, Lordship, last two lines, 10th January 2016. So it will cover my December deadline also, if they accept it. But unfortunately, Lordship, they issued the letter on 7/7, page 192. So I'm sorry, Lordship. 6/7. On 6/7, page 193, I informed them on 6/7 that I have already extended the bank guarantee to them. And they wrote a letter to the HDFC bank manager on 8/7, page 196. Here, encasement of bank guarantee, so it was forfeited. The other one. Previous page, Lordship will kindly come.
Previous case means. Previous case. A previous page, yes.
This is a letter from the central office to the office here in Guwahati. FCI minutes of SLC 14/5/2015. So they received it and they informed here. The third paragraph, SLC has also decided that if the party fails to submit land documents within 7/7/2015, the matter may be referred to HLC for consideration of his present request for extension up to 7/12/2015. In this regard, clear instructions has already been issued by the office circular dated 28/2013, which provides that if there is a delay in submission of required land documents beyond permissible limit, period of 1 year, SLC have been authorized to decide such matters on merit of each individual case. It is therefore requested to take action accordingly. After 14/5/2015, there has been no SLC meeting on my issue. They can say in their affidavit, they try to project that we have already taken a decision on 30th of April. So why should we take a fresh decision? But after that, subsequent development had taken place. My representation of 6th of May, their meeting on 14th of May, their communication to me on 10th of June, this communication of 6th of July, where the SLC is directed to take a call on that prayer. They took a call up to 7/7, but they did not take a call up to 7/12/2015. In this situation, they have forfeited. Now, my humble submission is that while you can give extension in so many other states, I have given their own documents. I am not making any documents on my side, from my side. That 11 months in JNK, 9 months in Kupwara, 2 months in Jharkhand. 9, 11, 2. In my case, practically, I have received only 2 extensions. One is for 17 days, 13 March to 31st March. In fact, 14 March to 31st March. The other is Lordship from 10th, received on 12th June till 7/7. So if we combine both these periods, because till I get the order of extension, my situation is very fragile. I cannot do anything. I do not know what will be the fate of my request.
Yes.
So practically speaking, Lordship, only 43 days I have received, and I have ensured also that in 4 months' time, I am going to give it. I am going to submit. By that time, things have smoothened down. So the learned single judge turned down my prayer for setting aside those forfeiture notices and forfeiture of my amount. In fact, I made a request that allow me to do the work on the ground that there was not sufficient material to convince the court that these issues were not genuine. These issues were genuine. Section 55 needs more materials. So what the learned single judge said that to invoke section 56 of the Contract Act, the particulars should be more accurate. It should be more convincing. I have produced 4 documents, 3 documents from 3 organizations, Prikhok Mukti, Tiwa Students Union, Nagaon Students Union, and the police report. The meeting of the FCI official said that the grounds which I have cited are found to be genuine.
Yes.
In that situation, in my humble submission, with extreme humility I am submitting, the learned single judge has committed a mistake. Because there is no dispute about that. The FCI is not disputing. They may write something in their affidavit, but their minutes very clearly says that the grounds are genuine. That is number 1. The learned single judge on the other hand, Lordship, we have not made this Prikhok Mukti Sangram Porikhod and other organizations a party in the writ petition, which was never their prayer also. We have no dispute with these organizations. Their record speaks. They are writing documents to the Deputy Commissioner, which we have annexed. And nobody is disputing, Lordship. The dispute should have come from the FCI. Third one is, Lordship, so more evidence is required. Then it is not a case of force majeure. Doctrine of frustration will not be invoked. And one very important paragraph 25, page 283. Lordship.
Yes.
283, this is the finding of the learned single judge, last 3 lines. The SLC rejected the request for extension up to 7/5/2015, which the petitioner raised before the SLC. However, with an observation that petitioner may move the HLC for extension of up to 7/12/2015. It is not our case that we have to raise a prayer before the HLC. They themselves have said, I have read out, Lordship, I have already placed it,
Yes.
that if the petitioner cannot produce the documents by 7/7/2015, then the matter will be referred to the HLC for taking the call regarding the prayer for granting extension up to 7/12/2015.
Yes, yes.
SLC did not reject that prayer.
Hmm.
SLC kept the prayer open. Basically, these are the facts.
Hmm. Yes.
So my humble submission is that, Lordship,
Hmm.
when I fail to fulfill the commitment of submitting the documents within 120 days,
Yes.
I have cited 3-4 grounds. They have also accepted. They granted extension from time to time, which was not adequate. And my final prayer to grant me extension up to 7/12/2015, they said that we cannot take this call. We are referring it to the HLC. Then HLC said that you are competent to take that call. That meeting till date has not taken place.
Oh, yes.
They cannot rely and go back to their earlier meetings, minutes or decision to give a decision. Because
Yes.
finally, who has taken the call to do this forfeiture of the amount and who wrote the letter? Before that, the decision should have been there that let us forfeit everything now. They themselves have said this gentleman on his own cannot take a decision on behalf of the SLC. That is why on all the minutes I was pointing out who are the persons who comprise of the SLC. SLC does not comprise of one single person, whoever he may be. There is a committee. They have 243. There are 8 or 9 persons, Lordship. Yes. The ED Zone FCI, Zonal Office NE, then GMR FCI RO, Guwahati, Deputy Commercial Manager NF Railway, Deputy Secretary FNCS, Government of Assam, Regional Manager CWC Guwahati, Deputy Secretary, Department of Agriculture, Government of Assam. So this committee will have to take a call, which comprises of officials from various departments, various wings of the society, of the administration. So after that, if they say that we have taken a fresh decision by the SLC, then Lordship, my cause of action would have been arisen differently. So these are the overall facts. The law is very simple, Lordship, in this regard. I am frustrated. The doctrine of frustration is applicable because in spite of my best efforts, I could not fulfill the target within 120 days. In May, I have said that give me 4 months. Now things have mellowed down. I will complete it in 4 months. That also they have given me practically from 12 June to 7th of, so hardly 27 or 26 days. Which is not, and they themselves in one of the minutes written that although we have given them the time, but that is not sufficient. We are sure he will not be able to submit the documents. So whatever extension they were giving me, they themselves know that these are not reasonable and practical extensions. For the sake of extensions they have given, whereas they have given extension of 11 months in JNK, and at the same breath they say that situation of JNK is not different with the situations of Assam. So this is my humble submission. In that view of the matter, Lordship, the learned single judge's order may be interfered with. It is not my fault that I could not. And subsequently, on 27th of December 2015, they issued another tender for the same work with a lower capacity, 30,000 metric ton. I came before this honorable court with a IA order. The IA order was said that it will subject to final order. But till now, nobody has been able to complete that project. So that means that force majeure, in fact, from the sequence of events with the influx of time is correct. This is my humble submission.
A simple, say one query, please answer. One by one, please pick out your letters of force majeure sent to them. Please
Yes.
take out the first letter.
First letter of January 2nd.
Read, please.
Yes, I'll read out. First letter, January 2nd.
Page 165.
Just 1 second, Lord.
165, 165.
163.
Please point out
160,
165.
165. That is the
Please.
first letter of second.
Please point out from any of these letters, whether you have referred to which were the organizations threatening you, or whether you have annexed the copies. You had the letters with you, which you have filed with the writ petition.
Yes.
Tell us from your letters, please.
Indicated some very powerful organ and their
Mr.
representatives.
Saikia, you claim to be having letters received before this
Yes,
communication.
yes, whether we have submitted to them or not.
No, the question here is whether you have mentioned it in this, any of your letters, or we have made an annexures. We don't find them. So that is
Yes.
the question mark on the genuineness of your claim. This is in reference to the finding that none of those so-called offensive organizations were a party in the writ petition. A very big question mark on the genuineness of these communications, sir.
But one thing I'd like to,
First, please answer this.
yes,
Very-
from this record, it does not indicate, number
No,
one,
no.
but powerful organization is mentioned,
Yes.
police in, thing is also mentioned.
Yes.
Number two, the minutes says that the reasons are found to be genuine.
All right. The minutes also say
So maybe
in public
separately
importance-
it has been given,
in
I do not
public-
know.
in public importance,
Yes.
it is necessary to get the go down
Yes,
complete.
highly, it is will be hyper technical because we have missed it, but I am sure they must have received it. Maybe separately. I leave it to your
Can't say-
lordship.
Can't say. Anyhow, we'll hear them. Yes.
In their minutes of that meeting of February, lordship, they have said that the reasons are found to be genuine.
That you argued. Yes. Yes, please.
I'll draw your lordship to a few more clauses of the tender.
Yes.
First.
Yes. Yes. Yes.
Under the tender clause, they will have to give a specific
Uh,
plot of land.
Where we are reading which conditions?
Page 82.
80,
82.
82. Yes.
Lordship, clause 16.
Just a moment.
I'll read a few clauses, my lord.
Yes, yes, sure.
Once you've got it, my lord, page 82.
Shall not be changed.
Yes, the specific location of the proposed land by the tender in the tender for the construction of godown shall not be changed at any stage after submission of the tender under any circumstances, failing which EMD supplementary security performance furnished by the tender liable to be forfeited, invoked as the case may. Next, my lord, will kindly come to page 83, clause 21.
Yes.
Tender should furnish a technical bid, all details of the location, survey number, proof of ownership, registered sale or original affidavit, mentioning details of the land which the tender undertakes to acquire, area indicating the boundaries along with the non-encumbrance certificate, sketch plan about the location of the land. The details of the land should be furnished adequately as suitability of the land for the intended purpose is one of the major criteria for selection of the tender. The land on which the godown is proposed to be constructed should not have a AST line 11 kV above passing over the proposed layout plan of the godown. FCI have a right to inspect the site from time to time, and the tenderer will carry out their directions regarding any corrective methods so and so. Any proposal for reduction of capacity or later stage shall not be entertained. Land must not be in the flood or water-prone, logging-prone area. Pollution industry should not be there in the vicinity. Sufficient land should be available. Ancillary work, a detailed layout plan, so and so given.
Yes.
Now, my lord, kindly come to page. Clause 42. Next page.
42.
For clause 42. 42 and 43, specific, my lord, page 83, 43, change of site
Will not be agreed.
by so and so.
Yes.
What happens? They have to give specific plot of land. We inspect that. So this is in competition because many land competing bidders are rejected.
Yes, of
And
course.
they came to the court.
Just like retail outlets of oil companies.
That's right, my lord.
Same process.
And they come to the court. It happened like this, my lord. One of the, my lord, unsuccessful bidder whose land was found to be flood prone area. He approached this court. His writ petition was dismissed. Writ appeal also was dismissed. Therefore, if he got this tender in a competition, he has shown the land. He cannot now change. He said, no, this plot is not suitable for me. The
Let me change the location.
Selling
Change the
to
location.
my competing bid. He also said land single judge has a finding, my lord. He said his competing bidder is creating troubles. So this cannot be ground, but he must take care of everything and then submit his tender.
Sure.
That is the purpose, my lord. And my lord, page 149. 149 is the land side given. This was accepted, my lord. 149.
Yes.
Here, my learned friend has shown it to your lordships. This is the land in Oguri village and the plot of land details he has given.
Yes.
So he cannot now say
No,
that
let me change the location.
if you change it, the tender will be liable to be the consequences given in this.
Yes.
And my lord, the SLC has considered this case twice. So he has no right under the terms of the contract or otherwise
To have it further reconsidered.
further be considered. There's no legal right, my lord. And he has not in the petition has made an allegation of arbitrariness, malafide, no such allegation specific. Which officer, who has done the malafide? Nothing. So on this itself, my lord, I think, my lord, the lordship, the change of site cannot be allowed.
Yes, no.
That is what the ground we have said. He could not, we have gone as per the terms of the contract only. We didn't go beyond.
Yes.
This is my submission.
All right. Anything else to say, sir? Argument heard, judgment reserved.
Deeply obliged.
Yes.
Item number 37.
These things become question relevant. Obviously, that is the indication. These were not there.
May I please your lordship? Lordship, this matter is led by Sri Kiran Chaudhary. He is on legs in court number 6. Kindly pass over the matter for time being, lordship.
The other day, Rochu wanted to know whether there is any call letter requiring the candidate to bring the essential document. There is a call letter in the application form also. There is a clause to endorse
We
all
don't remember what was the argument. What is the matter about? What is the matter about?
Lordship,
Ah, yes. There is no call letter.
Lordship, there is a call letter that was skipped in. Call letter is in fact here.
Is there? Hmm. What was his case that he experienced?
Lordship may also look into the advertisement. There is a clause. There is in the
Clause,
in the advertisement. Page 43.
just 43. Yes.
Serial 5. The copy to be annexed, the two copies and a recent passport size photograph duly signed by candidate on the reverse side. B. The attached copy of necessary educational certificate and other certificate. Lordship will find in the record. I have there's a application form which had to be submitted. Miller. There is a clause. Miller.
All right, let Ms. Chaudhary comes and please, Ms. Senior Advocate Ms. Chaudhary is reportedly busy in another court list after 10 days for hearing.
Item number 38.
Hearing consult. What was the number which we reserved? What was the number of the case? 28. Oh. Yes. Item number 38.
May it please your lordship.
Yes, yes.
On the last occasion, lordship has directed us to pay
Original record.
Yes, my lord. That's my lord.
You have the record?
Yes.
Okay. Just give us a brief outline of your case.
My lord, the NFL has proceeded a tender, my lord. The NFL authority has floated a tender, my lord. And my lord, the respondent has become the lowest tender, my lord.
Yes.
And accordingly, my lord, LOA was issued, my lord.
Okay.
But the thing is this, my lord, the LOA, my lord, we have sent through.
Concluded contract. Yes, yes.
My lord, the my lord, LOA was sent to the respondent, my lord, through registered post.
Yes.
As well as my lord.
Email.
Email.
Yes, okay.
Because my lord, this is an e-tender, my lord.
Yes.
All the documents were submitted.
So
my
that
lord.
was his argument was that we did not receive it.
Receivable, my lord.
And now with mail, what you have forwarded, let us see.
My lord.
That was probably what we wanted to see.
Yes, my lord.
Yes.
Yes, my lord. My lord, as we have stated, my lord, it was attempted, my lord, thrice to serve this letter, my lord.
All right. That's
my
what
lord,
we wanted to see.
Yes, my lord. Door locked.
Door locked.
Door locked, my lord. This is the, my lord. May please.
Yes, please.
That was what we wanted to see.
Yes. Deemed to be served. They have sent it, the correct address and mail. Mail it or? Yes. Yes.
And backside, my lord, that is.
Door lock.
Yes, my lord.
Yes.
Thrice, my lord. 3 dates, my lord.
3 dates
Yes,
postponement. Yes. And e-communication is admitted.
Yes, my lord. Admitted.
Mail has been received.
My lord.
Yes, now you can commence.
So, my lord, our contention is that, my lord, since.
Yes, you have to recapitulate the things. again.
Yes, my lord.
Yes.
Now, my lord, now, my lord, the conditions, my lord. Lordship may turn to page 29, my lord. How this, my lord? Page 29, my lord, clause 36, my lord, down below, my lord.
Page 29.
My lord, 29, my lord.
Yes, please.
Clause 36, my lord.
Performance guarantee.
Performance guarantee, my lord. May I read, my lord? The procedure for obtaining performance guarantee is outlined below. A successful leader shall have to submit a performance guarantee within 30 days from the date of issue of letter of acceptance.
Yes.
Extension of time for submission of PG beyond 30 days and up to the date of submission of PG from the date of issue of LOA may be given by the authority who is competent to sign the contract agreement.
Yes.
However, a penal interest of 15% per annum shall be charged for the delay beyond 30 days. That is from 31st day after the date of issue of LOA. In case the contractor fails to submit the requisite PG after 60 days from the date of issue of LOA, a notice shall be served to the contractor to deposit the PG
Yes.
immediately, however, not exceeding 90 days from the date of issue of LOA. In case the contractor fails to submit the requisite PG even after 90 days from the date of issue of LOA, the
Yes.
contract shall be terminated,
Yes.
duly forfeiting the EMD. And
Actually,
other
the word is not very happy. It should be offer shall be terminated.
my lord.
The word should not have been contract. It can be, the correct word would have been offer.
Offer, my lord. Yes, exactly. Exactly.
Submission.
Yes. Okay.
Exactly, my lord. And my lord, thereafter, my lord, railway have, NF Railway has, my lord, served him notices, my lord. And my
Where-
lord,
Where
the
is that?
respondent has received those notices, and my lord, lordship may kindly turn to page 20, my lord. The notices are to my lord.
Page 20. Yes.
Page 20, annex 3, my lord.
Yes.
My lord, subject, artwork, formation of embankment, my lord. This is the work, my lord.
Yes.
Reference office letter dated, office acceptance letter number so and so dated 18/1/2019. That is the
Yes.
LOA, my lord. 5 days office letter of acceptance referred above, you are required to submit a performance guarantee in the form of an irrevocable bank guarantee for an amount of equal to 5% of the contract value of rupees so and so within 30 days time, 90 days with penal interest of 15% per annum as per clause 36A of the tender document from the date of issue of letter of acceptance. In case you fail to submit the requisite fee within the prescribed time limit, the contract shall be terminated, duly forfeiting EMD and other dues against the contract, and you will be debarred from participating in
Yes.
in the retender of the work. My lord, this is number one, first letter, my lord. Second letter, my lord, next page. This is on, my lord, 20 March 2019, my lord.
Yes.
Subject is same, my lord. Reference, my lord. Letter dated 8/3/1990, my lord. Dear sir, in reference to above, it is directed to start the work in between the Thakurganj to Poakhali against.
How this direction could have been given? Even the contract was not signed. Your officials need more training.
My lord, the thing is this, my lord.
Yes.
I'd like to show from the LOA, my lord, the page 19, my lord.
Yes.
My lord, it starts from page 18, my lord. Lordship will see the language of this, my lord, LOA, my lord.
Yes.
Dear sir, your offer for the above noted work has been accepted by the
Yes.
competent
So
authority.
offer was to be accepted by the railways.
Yes, my lord.
Basically, acceptance is there
Yes,
from
my
the
lord.
railways. Yes.
And on behalf of the President of India,
Your,
total cost of rupees so and so,
yes.
so as per the enclosed schedule of rate and qualities.
Yes.
You are hereby authorized to commence work, my lord. So, my lord, this is my lord, the letter is to commence work, my lord. And my lord, The second was, my lord, if your lordship kindly see the second page, my lord. Second place, my lord, second para, my lord. The acceptance letter shall be legal and enforceable contract between you and railway.
Yes.
If you fail to execute the work or fail to execute formal contract agreement in
Yes.
accordance with the stipulation in the acceptance letter, it would make you liable for breach of contract, and railway administration shall be entitled to take recourse to an action as deemed fit in accordance with the stipulation of the tender.
Yes.
So, my lord, as per the tender condition, my lord,
Deposit. Yes. I've seen that. I've seen that. Yes.
so my lord, as per the tender condition, my lord, we have, my lord, cancel the my lord, contract, my lord, and my lord, and the my lord, earnest money was forfeited, my lord, as per this condition, my lord. And my lord, he has received those letters, my lord, and my lord, he has written some letters to the railway also, my lord. My lord, I'll draw your lordship attention to those letters, my lord, also, my lord. My lord, at page 178, my lord.
Just a moment. What is the date of refusal of the envelope? Can you point out from the record?
My lord. My lord, the refusal is, my lord, 31/2019, 31/1/2019,
1/2.
Yes, 1/2/2019. My lord, this is written as 1/1, my lord. Should have been 2, my lord, probably.
Yes. Now you are on 170,
My lord,
179.
178, my lord.
8. Yes, please.
My lord, this is, I'm showing this letter from his writ petition, my lord,
Yes.
that he has received this.
Yes.
letter.
Received.
My lord, same letter, my lord.
Yes, yes.
He has received, my lord. And my lord, this letter is of
Yes,
29/3/2019, my lord. And my lord, then after, my lord, the next page, my lord, 179, my lord, he has written a letter, my lord.
That he is trying to portray that he has received it. This is the acknowledgement virtually. Yes, he has replied to that.
My lord.
Yes.
179, my lord, he has written this letter, my lord, not to issue, to refund the earnest money, my lord.
Yes.
Nowhere he has written that he has not received the LOA, my lord.
Yes.
And my lord, and he has accepted this fact that these letters have been received. So he
Yes,
has
yes.
received the LOA. My lord, in spite of that fact, my lord, my lord, on the pretext of that, all the lands are not acquired. And my lord, I have shown from my lord affidavit in opposition.
That it was to be done in parts.
Parts, my lord.
Sections.
My
Yes.
lord, so my lord, we have already acquired some portion of the land, my lord. And
So
he
the
can
work
start
could have
the
been
work
started.
immediately,
Yes.
my lord. And my lord, the finding of the learned single judge, my lord, may point, my lord, at page 199, my lord.
Yes.
Para 13, my lord.
Para 13. Yes.
Page 199. The tender papers, those stipulate a condition for forfeiture of EMD, that is for furnishing a wrong information. The impugned forfeiture is, in the instant case, is not on account of the said condition. The forfeiture of the instant case is a consequence of termination of contract, filed impugned order dated 2/5/2019. The issue which requires to be determined is as to whether there was a concluded contract between the parties that could have been terminated. To come to a conclusion, one has to take recourse to the language of the tender and the documents connected thereto. There is a clear stipulation that the general condition of contract would be a part of the tender document. As per the same, though other modes of communication could be availed, all communication are required to be written and delivered. In the instant case, though it appears that there was an acceptance letter dated 18/1/2019, there is no material to come to a conclusion that the said letter was delivered to the petitioner in writing. The endorsement of the postal department is not refused, but endorsement is closed. Though an endorsement of refusal would have had a different connotation, When the non-delivery because of clause, there is no scope of drawing a presumption of service and delivery of letter 19/1/2019. That apart, this court also find force in the argument made on behalf of the petitioner that a stipulation in the acceptance letter dated 18/1/2019 regarding returning of duly signed duplicate copy in all pages to come to a binding contract is also relevant consideration, which admittedly has not been done in the instances. Though the learned standing counsel for the railway may have correct in contending that email of the acceptance letter has been accepted by the petitioner, that mode of communication is not to bring this court to a conclusion that the parties have arrived into a contract. Para 15, my lord, I am reading, my lord.
Yes.
In view of conclusion raised above, there is no concluded contract between the parties. The question of termination of contract would not arise. However, since the termination is not the subject matter of the petition, this court would refrain from making further comment on the said termination. However, the consequence of termination, which is forfeiture of EMD amounting to 51 lakh, is interfered with, and the same is hereby set aside. My lord,
Yes.
I will bring your lordship to the prayer, my lord. Where, my lord, the
Prayer of in the writ petition.
writ petition, my lord,
Just hold on.
at page 63, my lord,
Yes.
Roman 2, my lord, to set aside and quash the termination notice
Yes.
dated 2/5/2019. So, my lord, it's a specific prayer, my lord. So it is a subject matter of the writ petition, my lord. And my lord, the termination was availed while, my lord, the EMD, my lord, which is the consequences of termination, my lord.
Consequences.
My lord, please approach, my lord.
Yes. All right.
That is my humble submission.
You cited one judgment of
Yes, my lord.
2003 volume 7 SCC
Yes.
410.
Yes, my lord. Four judgments I have cited, my lord. One is, my lord, 2015 4 SCC, my lord. Para 14.7, my lord.
Have you
My lord.
provided copies?
Yes,
No.
my lord. I'll give the copies, my lord. My lord,
You've got extra copies with
no,
you?
my lord, I do not have, my lord.
Then all right, you read from this. We will get the books.
My lord.
You read from this. What is the proposition, please, in each case?
In this case, my lord, regarding,
Sure.
my lord, I want to point out, my lord, that the condition made in, my lord, section 73 and 74 of the Indian Contract Act does not come here, my lord. My lord, where it is, my lord, told that in para 43.7.
Which judgment?
Yeah, of, my lord, 2015 4 SCC 136, my lord.
Yes.
Para 14.7, my lord. Section 74 will apply in cases of forfeiture of earnest money under a contract, where, however, forfeiture takes place under the terms and condition of a public auction. Before agreement is reached, section 74 would have no application.
Yes. Yes.
Number one, my lord. Next, my lord.
Paras, you are reading para?
Para, my lord, 43.7, my lord.
43.7.
My lord.
Yes. Yes.
My lord. And my lord, next judgment, my lord, I would like to rely, my lord, 2003 7 SCC.
Yes.
410, my lord. Para 9, my lord.
Yes.
Para 9. In our view, the High Court fell error in so holding by invoking the bank guarantee and oblique or enforcing the bid security. There is no statutory right exercise of which was being fettered. There is no term in the contract which is contrary to the provision of the Indian Contract Act. The Indian Contract Act merely provides that a person can withdraw his offer before its acceptance. But withdrawal on an offer before it accepted is a completely different aspect from forfeiture of earnest public security money, which has been given for a particular purpose. A person may have a right to withdraw his offer, but it has it has made his offer on a condition that some earnest money will be forfeited for not entering into contract, or if some act is not performed. Then even though he may have right to withdraw his offer, he has no right to claim that the earnest oblique security be returned to him.
Yes.
My lord, this judgment has been relied in
All
2011
right.
also, my
The
lord.
basic judgment is there.
My
We
lord.
don't need
This
to.
is the basic judgment, my lord.
Yes.
And my lord, last one is my lord. 2015, my lord.
That's more than enough, Mr. Counsel. All right.
My lord,
Yes.
deeply honest.
My lord, before starting the argument, my lord, I want to have a look at this letter, my lord.
What letter?
The registered
That is-
post which was returned.
Show it to him. All right. Yes. Do you deny receiving the email, sir? It was an
Emails I have
e-tender.
received, but
It is an e-tender.
now, my lord, the email, through the email, 2 copies of the acceptance letter was sent, which was
Yes.
not a complete acceptance letter.
This was not the pleading in the red court.
Now, here I am coming to that.
Yes, please.
Acceptance letter, my lord.
Hmm.
First of all, my lord, in their counter affidavit, they have not filed any annexures before the learner.
Why were they required to?
Now I am
Your
coming,
own
my-
documents are
Let me
sufficient.
complete, my lord. Now, he has filed this acceptance letter page number 18, which is not the part of the record also. This is different from the other. Now he has
Yes,
filed this,
The part of the original record.
not part of the original.
That is a part of the original record. We can
Yes.
look into
original.
the record.
Yes, yes, original.
Yes.
Now letter dated 23/2019, annexure 20, page 21, annexure 4. This is also not part of the record. Now your lordship may kindly come to page 169, acceptance letter which was sent through the email is there.
Mm. Yes.
Then it ends.
It's the
at
same letter,
Not
which is
same
at page
letter.
18.
Not same letter, my lord. I am coming to that. Let
Okay.
me complete, my lord.
Yeah.
Now, page 170, my lord.
Mm.
An additional copy of this acceptance letter is also enclosed herewith, which may be returned duly signed in all pages for binding contract.
Yes.
Now, annexure is there. Schedule of items of work quantities and accepted rate. This is not available. Performance, performa of BG bond for performance guarantee. This is also required to be given.
Yes.
Additional copy of this acceptance letter is also required to be given.
Mm.
Now here, this for information and necessary action in the bottom. This is not available in the first acceptance letter which has been annexed by them.
Yes.
A copy of the schedule showing the acceptance letter is enclosed for your information and advised to the monitor the work closely and ensure timely completion. Now I
Yes.
want to see whether they sent the acceptance letter to the register post, whether that acceptance letter is.
Sir, is it your case that you could not execute the contract because you did not receive this document?
That is a different thing.
That is the very crux of the things, Mr.
My lord,
Counsel.
crux of the thing is, my lord, whether the contract is concluded or not.
All right, that argument
This
will
is
take.
my argument.
Oh, yes. We'll
Yes.
take note of that.
My only argument is that the contract was not concluded.
Very well.
Now, and once the contract is not concluded, there cannot be any question of forfeiture of
Yes.
the
Yes.
earnest money, my lord.
Yes.
Now, I am coming to this section 4 of the Indian Contract Act.
Yes, please.
Section 4, my lord.
Yes, please.
The communication of a proposal is complete when it comes to the knowledge of the person to whom it is made. The communication of an acceptance is complete as against the proposer when it is put in a course of transmission to him so as to be out of the power of the acceptor. As against the acceptor when it comes to the knowledge of the proposer. Now illustration A. A proposes by letter to sell a house to B at a certain price. The communication of the proposal is complete when B receives the letter. B accepts the A's proposal by a letter sent by post. The communication of the acceptance is complete as against A when the letter is posted. Now I am coming to section 7, my lord. Acceptance must be absolute. In order to convert a proposal into a promise, the acceptance must be absolute and unqualified. Be expressed in some usual and reasonable manner unless the proposal prescribe the manner in which it is to be accepted. And if the proposal prescribe a manner in which it is to be accepted and the acceptance is not made in such manner, the proposer may within a reasonable time after now, if it is proposal is provided, my lord. Here, this, I am coming to my lord, this affidavit in reply. Because tender is there and part of the tender is the GCC 2013, my lord. Page number 3, my lord.
Where are you reading from?
My lord, these are not a part of the record. It is in this original record, my lord. Affidavit in reply, my lord.
Page.
Page 7, my lord. This is part of the tender as this is being the part of the GCC. The communication, I have quoted the
Yes.
the communication to be in writing. All notices, communications, reference and complaint made by the railway or the engineer's representative or the contractor interest concerning the work shall be in writing. And no notice communication, reference or complaint is not writing shall be recognized. Now, section 27 of the general clauses Act says by law. Meaning of service by post. Where any central or regulation made after the commencement of this act authorizes or requires any document to be served by post, whether the expression serve or either of the expression give or send or any other expression used, then unless a different intention appears, the service shall be deemed to have been effected by properly addressing a prepaying and posting by registered post. We don't know what is the address on that. A letter containing the document, and unless the contrary is proved to have been effected at the time at which the letter would be delivered in the ordinary course of post. Now, then I am coming to page number, my lord. Page number, my lord, 173.
Of the appeal?
172, my lord, of the writ appeal, my lord.
Yes. 172. Yes, please.
As per your letter, so and so, we are mailing a letter number so and so for extending the tender validity. But field survey are found that only approximately 30% of the land acquired from the chainage number so and so between station Pawakha to Thakurganj, and rest of the land not acquired. Secondly, in which area where the land is already acquired, where the local people cutting the earth which is in the railway alignment and sell to bricks field, this news is already printed in the local newspaper. This has not been denied by them. Now, now your lordship may kindly come to my affidavit in reply. Last page, page 22, my lord. Railway board circular is there.
Yes.
Last paragraph, my lord. Instructions have been issued by the board from time to time enjoining upon the railway to take up works for execution only after suitable investigation have been completed. Detailed drawings and plans have been approved and detailed estimate urgency certificate sanctioned by the competent authority. Attention is also invited to para 1002 of the Indian Railway Code for Engineering Department, as also to board letter number so and so. Board desired to reiterate that the contracts for work should not be awarded unless soil test, site investigation have been completed, all plans, drawings and estimate duly approved, sanctioned by the competent authority,
and that there is no hitch in handing over the site. Site was not taken over by the railway. This is also in violation of the guidelines of the Indian Railway. So, and there is no pleading that they have suffered any loss for the non-completion of the contract, my lord. It is also not there pleading that the contract is concluded. And in support of my submission, my lord, I am referring this judgment.
Yes. Yes.
Paragraph 52, my lord. There is a wholesome principle that the courts have been following for a very long time, and which was articulated in Nazir Ahmad versus King Emperor, AIR 1936 PC 253, namely, where a power is given to do a certain thing in a certain way, the thing must be done in that way, or not at all. Other methods of performance are necessarily forbidden. There is no valid reason to give up this salutary principle or not to apply it mutatis mutandis to bid documents. This principle deserves to be applied in contextual disputes, particularly in commercial matters, or bids leading up to the commercial contract, where there is a stiff competition. It must follow from the application of the principle laid down in Nazir Ahmad that if the employer prescribes a particular format of the bank guarantee to be furnished, then bidder ought to submit the bank guarantee in that format only and not in any other format. However, I mentioned above, there is no inflexibility in this regard, and an error could deviate from the terms of the bid documents, but only within the parameters mentioned above. Now, I am coming to this their ground. Writ appeal, my lord. Now we cannot travel beyond their ground because they preferred the appeal on the grounds. Basically, what is their ground, my lord, I am coming to that. Page number, my lord, 14, paragraph 6.
Yes.
For that, the London single judge has erred in law as well as in facts in allowing the writ petition, in spite of the fact that the honorable single judge in its order dated 25/3/2021 has held that the tender paper, though it stipulates a condition for forfeiture of EMD for furnishing wrong information, the impugned forfeiture in the instant case is not on account of the said condition. The forfeiture in the case is a consequence of termination of contract. Their plea is only for the termination of contract. That is why they have forfeited. Now the learned single judge has arrived at the conclusion that there is no concluded contract. There is no question of termination.
Of course, we understand.
Second judgment, my lord. And there is no averment either in the affidavit in opposition or in the writ appeal that the contract is concluded and how it is concluded. There is no justification at all.
Very well.
Next. Paragraph 8, my lord, I am referring. We may also take note of another significant fact at this stage, though an attempt has been made on behalf of the Union of India to assert that retention forfeiture of license fees on account of damage losses suffered. Now the highlighted portion, my lord. Even remotely attempted to place relevant materials in this regard to show that the action of the licensee in refusing to act in response to LOI granted to them had occasioned losses, damages for which Union of India is liable to be compensated. Now, paragraph 10, my lord. Coming to the aforesaid question of availability of a power to order forfeiture, a reading of the relevant clause 8, 5, 10D, and 12 extracted above would go to show that the union had not protected, empowered itself to forfeit the license fee. The forfeiture contemplated by the aforesaid clauses are altogether in different contexts and situations. In the absence of such power, the forfeiture that has taken place in this case will have to be adjudged as null and void. Now, there is another judgment on the forfeiture of the earnest money. This is important judgment. So far, my case is concerned. My
Yes.
last page, my lord.
At least read out the citation. The other side is entitled to know.
Citation 2017, my lord, volume 13, SCC, page 243. Vedanta Limited
Yes.
versus Emirates Trading Agency, LLC. And then I am referring in paragraph 13 and 15, my lord. The highlighted portion, my lord. As seen, the material alteration in the contract make a world of difference to draw an inference of a concluded contract. In the absence, paragraph 15, my lord. In absence of a concluded contract between the parties having been established by the respondent, the claim under section 73 of the act was not maintainable. The impugned order are therefore held to be unsustainable and are set aside. Then another is also important.
Forfeiture. Relevant, irrelevant.
This is very important and this will clear picture of my case, my lord.
Yes.
This is my lord. 2007, volume 2, SCC, page 624. Yogesh Mehta versus custodian appointed under the social code and others. And I am referring, my lord, paragraph 32. While directing forfeiture of earnest money, the provisions of Contract Act 1872 are to be kept in mind. Forfeiture is impossible only when a concluded contract has come into being and not prior to that. And here, this is very important. Judgment is the formula box versus Union of India. If I am not, this is a 5-bench judgment perhaps. And on receipt of the notice, my lord, one judgment is there. Only one copy I have. 2010, my lord, volume 9, SCC, page 157. Greater Mohali Area Development Authority versus Manju Jain.
Yes.
And I have only one copy, my lord, so I am reading this paragraph. Paragraph 22, my lord, 23 and 24.
Please read the citation once again.
Yes, my lord.
2010.
volume 9, SCC.
Yes.
Page 157.
Yes.
Greater Mohali Area Development Authority versus Manju Jain.
Yes.
And I am referring, my lord, paragraph 22, 23 and 24. The constitution benches of this court in Bachittar Singh versus the state of Punjab and state of Punjab versus Amar Singh Harika have held that an order does not become effective unless it is published and communicated to the person concerned. Before the communication, the order cannot be regarded as.
Yes, carry on.
Before the communication, the order cannot be regarded as anything more than provisional in nature. A similar review has been reiterated in Union of India versus Dinanath Kantaram Karekar. Paragraph 23, my lord. This court in Lakshmi Narayan R. Bhattal versus the state of Maharashtra, this court held that the order of authority must be communicated for conferring an enforceable right. And in case the order has been passed and not communicated, it does not create any legal right in favor of the party. Thus, in view of the above, it can be held that if an order is passed but not communicated to the party concerned, it does not create any legal right which can be enforced through the court of law, as it does not become effective till it is communicated. So my whole submission is there. My lord, the contract was not concluded as per the requirement of the Indian Contract Act, as per the requirement and terms of the tender. And there is no infirmity in the order passed by the Honorable Learned Single Judge. And so there is no merit. This appeal is devoid of merit and liable to be dismissed.
Well,
This is much obliged.
anything to say?
One thing, my lord, I'll try to, my lord, so my lord, one page, my lord, page 30, my lord, inspection of site, my lord. My lord,
Yes.
where it is categorically stated how my lord inspection has been written. At page 30, annex 9. My lord, clause 19.1 and 19.2, my lord.
Yes.
The tenderer shall in their own interest examine the drawing, condition of the contract and specification of work. They shall also inspect site and satisfy themselves of their own as to the hydrological, climatic and physical condition prevailing at the site, the nature, extent and practicability of the work, all existing and required road and other means of communication. Across to the site, whether by weather or land availability of housing and other facilities.
So basically, this is the principle of buyer beware.
Yes, my lord.
If you are entering into some bid, you should know what exists at site.
Yes, but the next 19.2 is more specific, my lord.
Yes.
There should be any
Should
discrepancy
there be any discrepancy? Yes.
or any doubt
Yes.
or obscurity as to the meaning of any of the tender document or as to the anything to be done or not to be done by the tenderer or the instruction to be observed by him. He must set forth in writing such discrepancies, doubt or obscurities and submit the same to the General Manager Construction NF Railway, Maligaon, Guwahati for elucidating as soon as possible, but not later than 10 days before the last date fixed for receipt of the tender. Any complaint he has to make before filing of the tender, not after that. And next, the money has been forfeited on the basis of the tender condition, not on the basis of the contract.
Very well.
Argument, sir. My lord, the contractor has no role to play in execution of the land, my lord. This is my.
Argument, sir. Judgment.
Item number 39 and 40.
Lordship, kindly pass over the case as my senior is on leagues.
Lord,
Please,
Lord, we have some urgency, my lord. Can we pray for a date, my lord? Some date, my lord.
Maybe in July now,
Lord,
20th July.
appellants are going to retire, my lord. That's
Can't be helped, sir. No.
obliged.
Yes.
Item 41 and 42.
You take the note. Cooperative societies. Yes.
Look, there are two connected appeals. But I am representing well the appellant in item 42, that is writ appeal 98.
Who is there in the other matter? We can't decide the cases separately now.
In fact, my lord, so far as the order of the Honorable Single Judge is concerned, my lord,
yes,
that has virtually become infructuous. But so far as the my lord, observations in para 27 is concerned, that is in conflict, my lord, with the express provisions of law. So therefore, para 27 requires to be adjudicated. Because if your lordship comes to the preceding paragraph, para 26, my lord, if I take your lordships to page 32 of the appeal, the Honorable Single Judge has categorically held that the secretary, my lord, appointed by the government would, my lord, hold his office until a board is formed in the instant case. Now, by this time, election has been held and the board is constituted. So in that regard, a direction may go that the board will appoint, my lord, the secretary under section 38(2). In that context, my lord, this has become infructuous. But so far as the observations and directions in para 27 is concerned, this is, my lord, in direct conflict with, my lord, two provisions of the Act. Here, the honorable single judge has directed the government, my lord, to appoint the secretary, or which is known as the chief executive, my lord, until the board is, my lord, is constituted. My humble submission is, my lord, there are two provisions under the Act. One, section 48, and another, my lord, section 49 of the Act. Now, to appoint, my lord, a secretary under these two provisions, my lord, certain conditions must be met. Unless those conditions are present, my lord, the appointment by the government, my lord, is not permissible. So if I take your
we'll consider this in a suitable litigation. Why agitate this cause here now? Since you yourself say that now the society is in place, the elected society is in place.
Yeah.
Why unnecessary go into this academic?
No, only, my lord, I want and, my lord, observations from your lordship, my lord, that this is not permissible in the teeth of section 48 and 49. Only that observation, my lord, because it would have a ramification.
Let's see, Cooperative Societies Act.
Two small provisions, my lord.
Precisely. Who elected body का discretion. Yes. Administrative. Yes. Precisely. Functioning properly or not. Precisely. He is the only person. You are referring to?
Yes, my lord, before that, I take your lordships to para 38 subsection 2. This is the, my lord, source of power under which the authority, that is the board, my lord, appoints the, my lord, chief executive or the secretary, my lord. In normal parlance, we say secretary. 38(2), my lord. To nominate, elect, or appoint and remove the
38(2), yes.
38(2) to nominate, elect, or appoint and remove the chief executive, provided it's not a government appointee. So, my lord, he is the.
So there is a scope for a government appointee also.
There is a scope that is reflected in 48 and 49.
Yes.
If now your lordship will come to 48.
Elected board nahi hota hoga. Then yes. When the elected board is not in place, probably 48.
Yes, 48 your lordship will come. The state government may, on application supported by a resolution of the board of a registered cooperative society, and on such terms and conditions, depute government officials to the service of the cooperative society for the purpose of managing the affairs of the cooperative society, and the officials shall exercise such powers and such duties as determined by the state government and acceptable by the borrowing cooperative society. Now your lordship will see there has to be an application by the board and supported by resolution. Unless that is there, my lord, the government, my lord, will not appoint or cannot appoint one. That is the stipulation of section 48.
But supposing the board is dissolved and there is a crisis of administration, then what happens?
My lord, when the board is dissolved, under section 41(6), my lord, a departmental officer of the corporation department is appointed.
Let us see.
And the secretary always remains, my lord, because he is the my lord, employee of the board.
Employee of the board.
Yes, my lord. He remains.
Permanent employee.
Yes, permanent employee. And if your lordship comes to 41, I directly take your lordships to this, my lord, query. The answer is 41(6), my lord.
Yes.
Where a board fails to arrange for holding election before the expiry of the term of the board, or delegates, or where there are no directors remaining on the board, the registrar shall convene a general meeting by appointing an officer of the cooperative department for constitution of the board within 90 days from the date of such appointment, and the officers who appointed shall perform all functions of the board during the said period of 90 days.
So you say secretary is a permanent feature.
Yes.
Where do we get that from?
My lord, your lordship will come to 49. 49(b), my lord.
Chief
executive shall
Chief
be the
executive in definition clause.
Yes.
Means individual in paid or honorary capacity nominated or elected or appointed by the board from amongst members, directors or others in accordance with the bylaws of the society.
So he's appointed by the board.
This is chief executive.
Secretary can't define it. Is there any description of what is a secretary? How do you say that a secretary and a chief executive is same?
Well, secretary and chief executive is same. In normal parlance, we call it secretary.
Otherwise, it
we can
is
say
chief executive.
Yes, that is not disputed.
There is no
That
secretary.
is not under
as
dispute.
such.
Now,
There is
if
no
your
term
lordship
like
comes to
secretary.
49B, the chief executive shall be the ex officio member of the board. And two, my lord, the chief executive, 49(2), shall be under the general superintendent's direction and control of the board and exercise the following powers and functions.
Secretarial functions are provided. 49(2) they can. Secretarial functions, sir.
And your lordship will also see 49(1), my lord, in the event of appointment of the chief executive by the board, he shall be a full-time employee of the society. This is in 49(1). Now, your lordship sees, my lord, there are two provisions under the Act, 48 and 49. Now, so far as 49, my lord, C is concerned, under 49, my lord, 1C, the state government is empowered to appoint a secretary, provided that the state government stands as a guarantor.
Only in that situation.
Yes, my lord, in respect of the loan, my lord, taken by the society from a financial institutions, my lord. Otherwise not. So these conditions, my lord, must be present. So, my lord, my humble submission, in the present case, it was not a case that it had either fallen under 48 or 49.
No, it is not.
So therefore, such a direction could not have been given, in my humble submission, by the honorable single judge, my lord.
Only this much of clarification you want.
Yes, and third, my lord, secondly, honorable single judge says, my lord, that the registrar has no power even to appoint a, my lord, secretary on interest basis. My lord, my submission is, when the board is not in existence, and secondly, when the conditions under 48 and 49
are
is also not present,
prevailing.
the registrar, my lord, having regard to the all-pervasive power, right from formation to dissolution, my lord, the registrar has an inherent power to manage, my lord, the temporary recess, my lord.
Yes.
Or which has, there is a lacuna, my lord, or there is some gap, my lord. To fill up that gap, the registrar would have, my lord, the powers. Otherwise, my lord, the society cannot run, my lord.
Yes. Mr. Chaudhary, what do you say?
My lord, one clarification regarding that post of the chief executive, your lordship query, my lord, that has been defined.
That has been?
Chief executive, my lord.
Yes.
That has been defined in the section 2L.
2L, we have read that.
Yes, my lord.
So basically, it is a secretarial functions are given to the chief executive.
Yes, my lord.
As per 49(2) also. So except for the situations in 48 and 49C, state government has no role in appointing a chief executive.
My lord, the interpretation of the honorable single judge in paragraph 27, my lord, it has, my lord, it has given a clear finding.
Little vague, and it may cause problems later. We can clarify that and leave the things at that. Close the appeals if you feel.
Otherwise, my lord, the matter was not decided on merit, only on this ground, my lord, the writ petition was allowed. But on merit, my lord, it was not heard.
But now the elections have been
held.
Board is in place.
Correct. New board has come.
So now he only seeks a clarification on para 27.
My lord, for the interpretation of the, my lord, section 49, to your lordship's satisfaction, my lord, I am not affected.
You appear for?
I am the writ petitioner, my lord.
Writ petitioner, okay.
In view of the holding of the election and coming up of the new board.
So 41(6), the registrar has the power, not the state government. That is what his argument is. The single bench holds that it is the state government, even in 41(6). Appears to be a wrong interpretation. Who appears for the registrar cooperative society?
My lord, I am appearing.
You are appearing.
My lord.
Okay.
My lord, your lordship will take into, my lord, make this order part of the records, where it is reflected, my lord, the election has been held and the board is also constituted, my lord. Now the board will appoint under 38.
What about that second writ appeal?
My lord,
Rahman?
yes, my lord, filed by my learned friend. By him, my lord. Second writ appeal.
Okay. Yes.
Yes, my lord. In my appeal, my lord.
Government appointed secretary.
No.
Registrars. Yes.
So, my lord,
You are appearing in which case, sir?
my lord, 41, my lord. Appeal.
Niloy Bhushan.
Niloy Bhushan, my lord.
Yes.
My lord, the main disputes are between, my lord, this appellant and respondent number 7 in my case, my lord. My learned senior counsel appeared, my lord, for which. So, my lord, the learned single judge, my lord, did not go to the merit, my lord, as my learned saying. So, my lord, this order, my lord, which was passed by the registrar, my lord, page number, my lord, 63, which was impugned in the writ petition, my lord.
Yes.
That was not decided on merit. Whether, my lord, it is, because this order was passed on the earlier, the matter was remanded back to the registrar under section 1.
What was that order in reference to?
My lord.
Appointment of secretary.
Yes, my lord.
You were appointed by whom?
My lord, by the earlier elected body, my lord.
Elected body.
Yes.
So now there is a new body in place.
Yes, my lord.
That body will appoint.
Yes, my lord. Definitely.
So what is to be decided now?
Yes, my lord. In this order, my lord, this impugned order, it was directed, my lord, that till the next resolution taken by regular boards, nullification single is allowed. Page number 65. So till the page number 65, my lord, the direction of the registrar was there after.
So now has the board taken a decision now?
No, my lord.
No, my lord, due to the pendency of this
One
matter.
aspect in the matter, my lord. As my learned friend said, my lord, I have to state that it has not been, my lord, decided on merit. I was appointed because, my lord, his client, my lord, was resigned.
Resigned.
Yes.
Okay.
And whether that resignation is valid or not, that is that was the
Subject matter of writ petition.
Let that be decided, my lord, because
But now,
if
why should we go into that? Let the board take the decision to appoint the secretary. We'll clarify.
the question will be, my lord, he is no longer in service.
Who?
His client is no longer in service.
Yes.
So, my lord, the issue will be whether he's in service or not, whether that resignation was.
Is it a government service? Is it not a public service?
No, he's appointment of the board, appointee of the board, my lord.
Yes. So now a new board is in place. New board has a right to appoint its own chief executive.
No, the question is, my lord, whether he is in the job at all or not, my lord, of the board.
Job means what?
As
It's
the-
not a structured job kind of thing. It depends on the decision of the board who's to continue. If he has any claim for salary or anything, he may agitate that claim before the appropriate forum.
That may be clarified.
Yes. What do you say?
Obliged, my lord. This is my prayer, my lord, that since the new board is constituted, my lord.
Yes.
So as per this registrar's order,
Yes.
since my continuance was up to the constitution of the new board, my lord,
Yes.
as per registrar order.
Who represents the elected body? The board is not before us.
No.
The elected board is not before us.
During pendency of this.
There was no board, my lord.
No
because
board.
the Departmental officer was running.
Departmental.
Now, everything has become infructuous. Your lordship will direct, new board has come in. The board will take a
Board will
decision
take a
under
call.
38(2), my lord.
Yes,
Matter ends there. And your lordship will make an observation in respect of para 27.
that will do.
That is
All
not
right.
permissible, man.
Both means disposed of.
Deeply obliged.
Obliged.
Item number 43.
Page 63, maybe we can listen.
63. Even before reaching the dais, he was so confident. Look at 63 and decide.
Hello, I'm saying,
Yes.
your lordship, kindly see this order. This was the settlement order in favor of the present appellant.
Yes.
Well, writ petitioner's tender was found to be defective, technically defective. And the present appellant, my lord, he was respondent number 7. His bid was 7.5 lakhs.
Yes.
So he came before the court saying that my bid is 11.2 lakhs.
Bid is higher, so
My bid is
accept
high.
it.
Technically, his bid was rejected, my lord.
Yes,
So
yes.
therefore, question of counting his bid doesn't arise.
Absolutely no.
So
Financial
therefore,
bid can't be opened. Yes.
Now, learned single judge, my lord, page 25. It says because highest bidder on the basis of a order passed by the division, which says highest valid bidder should be accepted. So it says.
If there is a technical evaluation,
Yes.
the
So
bidder
this-
has to succeed therein first.
Yes. Well,
Yes.
So this part of the 11 lakhs, his tender was found to be technically defective. Question of opening price which doesn't arise.
Yes,
So learned
yes.
single judge says he has given.
Whether
high
this
grade.
aspect was not even considered
Not a-
regarding failure in technical
No,
bid. Where is that decision, please?
Affidavit filed by the opposite party, page 48.
48. What is the status? Is the order stayed?
In view of this order, I think they are running.
They are running.
Yes, ma'am.
Lordship,
Lordship,
the matter was sent back.
I'm for the fishery lordship, FDC. The fact is.
You are for?
I'm for the FDC lordship. That's it. Government lordship.
Settling.
Government.
Lordship. Lordship, here lordship, it is a single bid system. It is a single bid system, lordship.
Yes.
It was not that technical is what is examined first, then financial is examined later.
In any event,
In
what is
any-
the standing of the bidder in technical
Lordship,
evaluation?
Here the fact is that this order was passed considering with agreement all the parties, lordship. Here lordship, there was a risk petition. That order is there, lordship. Before the division bench.
First, let us see the evaluation wherein his bid was rejected. Where is that? The bid of the writ petitioner was rejected. Where is that decision?
63.
63 is accepting the bid of the appellant.
Lordship.
Where is the decision to reject? All right, here it is. Two
Lordship.
technical valid bidders, Pavan Hazarika,
Lordship.
and have been found to be genuine.
Lordship.
So
Lordship, here, his bid, the highest bidder was rejected.
you are going against your decision, own decision,
Yes, we have.
arguing against on your own decision. You are virtually arguing against your own decision.
No, lordship, may I say, lordship? Yeah, lordship.
First, make it clear, is that the situation?
Lordship.
You are arguing against your own decision, right? We'll take note of this fact then.
Their affidavit is at page 48.
Lordship, here, lordship, page number
Page
48. Before, wait, lordship, my lord, kindly go, before that, kindly go to the order, lordship. May I
Paragraph
impugn order,
6.
lordship, impugn order, page number 25. lordship.
Paragraph 6.
May I read, lordship?
Mr. Counsel, first, please make a statement. Are you arguing against your own decision? Do you call your earlier decision to be faulty?
Yes, lordship.
Where is the decision to call it faulty?
Lordship, here, that decision was, this decision.
That was virtually coerced by the single bench order.
No, lordship, this double bench, the division bench order, lordship, this order is being reversed because of the division bench order, lordship. There is a writ appeal, lordship, going on.
It has been reversed suo moto.
Lordship, no, lordship, there was in similar orders, in similar circumstances, lordship, in the case of this.
Where is the reversal of his bid? Let us know. Where is that order?
Lordship,
Whereby his bid has been cancelled. And the settlement has been made in his favor. Where is that order?
Lordship, it is not a, lordship, may I read the impugn order? It will be
Mr.
clear,
Counsel, will you please stop beating about the bush?
lordship.
Where is the order whereby his bid was settled? Settlement was awarded to him. Where is that order?
Later on, it was ordered.
Where is it? Yes. Where does this order deal with the technical bid aspect wherein they were found non-responsive? You got a copy?
Lordship, yes, lordship.
Does this order deal with the aspect where the highest bidder was found to be technically non-compliant?
Lordship, here it was not, here the.
Yes. Where does the single bench say, about what does the single bench say about the technical bid
Lordship,
aspect, technical evaluation?
Lordship, page number 27, lordship.
Yeah, read.
Also, I'm reading the, that is, I'm reading from the first part of the 27, lordship. During the deliberation of the matter, the petitioner as well as the respondent AFDC and the private respondent.
Just hold on. Read the second last para.
It is submitted by the petitioner.
In the case at hand, page 27.
Yes, Lordship. In the case and the petitioner was considered to be a technical.
Is this a correct observation?
No, Lord, and thereafter, while opening his financial bid, he was found to be the highest bidder, offering rupees 11 lakhs as well as settlement involved in the case. It is submitted by the petitioner that the following the provisions of Assam fishery rules, the finding no valid reason for settling the fishery. Here, Lordship, the reason for his rejection, Lordship, may I say, Lordship, here the reason for rejecting the affidavit visa, which we have settled later on, Lordship, was only because he has only on a superficial thing that he was.
Does the single judge give a finding on that? Where is the finding? Read. What is the finding on the technical bid aspect?
It is submitted petition following the provision of some fishery rules. After considering the entire aspect, the matter, including the judgment and order passed in the division bench or writ appeal number so and so, and on hearing the learned counsel.
Mr. Counsel, this is a bid evaluation process for a particular settlement.
Lordship.
Judgment of division bench, why it is applicable? No reasoning. The failure of the highest bidder on technical aspect, not discussed. How this observation comes in that the writ petitioner was considered to be a technically sound bidder? Where from this comes in? Did you say so in affidavit?
In the affidavit, Lordship, here this order is being passed, not considering the affidavit, Lordship. Here, Lordship, we are only considering this division bench order.
Yeah, that is a different thing, sir. That's a different thing. That's a different thing. Question is, this is tender process. Applicable or not? Yes. Where from this finding comes in, gentlemen, that is a technically qualified bidder.
That was, Lordship, later on it was here, Lordship, similarly situated situation, Lordship, here in this order.
Keep your managing director present in the court tomorrow.
Lordship. Lordship, before that, Lordship, may I pray, Lordship, regarding this fact, may I give a reasoning by giving an affidavit, Lordship?
No, absolutely no. Your reasoning is there. Your affidavit is there before single bench. Can you result from that? Can you result from that? We've asked you 3 queries.
Lordship.
In your affidavit, you clearly stated he is not technically qualified.
Lordship.
In the order also, it's so stated. Single bench observes that he is a technically qualified bidder.
Lordship.
How do you support that observation?
Lordship, that part we are supporting on the basis of this writ appeal, Lordship. The order of the
because of the writ appeal judgment, he becomes a technically qualified bidder.
Here, Lordship, both the parties, Lordship, before in the page number 27, Lordship, during the deliberation of the matter, the petitioner as well as the respondent AFDC and the private respondent have placed before the court that in similar circumstances regarding settlement of a fishery of the respondent.
What is the similarity?
That's I want to explain, Lordship. I'm not being able to convince Lord. That part, Lordship.
What is the similarity? It should have been reflected in your order that these facts are similar. Your order is silent about that.
Lordship. That part.
Once you have declared him technically unsound,
Lordship,
how can you hold him to be technically sound? We'll ask your managing director. Keep him present.
Lordship,
keep your managing director present here.
Lordship.
The managing director, Assam Fisheries Department, Development Corporation, shall remain present in the court on Monday, placed on Monday.
Oblige. Highly obliged.
So keep it on Tuesday. Tuesday, 6th.
Can it be on Wednesday, Lordship?
Wednesday. And you better come up with a good explanation. This is on the face of it a farce exercise. We are telling you. Exercise is absolutely farce. Better come up with a good explanation. It is not apparently available. Then place this order on record. When counsel Mr. So-and-so has placed a copy of the order dated 21/6/22.
May I pray one thing, Lordship?
Yes.
May I pray, Lordship? Instead of Lordship, may I pray for a affidavit to be explaining the reason, Lordship?
Why? The explanation is there from the document. You can't go beyond that.
Lordship, then also.
Your earlier affidavit, can we overlook it?
Lordship, that part, here, Lordship, yeah, that, in earlier cases, Lordship, in the earlier stage of that managing director was already been suspended and his FIR was also being done in the earlier case, Lordship.
The managing director who issued this order.
No, the managing director who issued the order did.
Why not we place this one in under suspension?
No, Lordship, Lordship. Lordship, he actually, he developed, he already did all of the good things, Lordship, in the Precedent department, Lordship, in this corporation, Lordship. Earlier one is already been behind the. Earlier one going to.
We can remand the matter to the single bench to give reasoning. There are no reasons at all. What do you say, sir?
I'm not single bench, well, it will go before.
No, it will go before the bench, whosoever is hearing. Whosoever is hearing the matter, it will go as per roster. This is not a review. We will set aside the order and remand.
Yes.
Very well.
Only page 70 or what you have, it is not a single bid system, it is a two bid.
We are not commenting on that. We are basically on the aspect, single bench says that the highest bidder was technically sound.
Yes.
Whereas their affidavit is on the contrary, with the contrary.
Order of settlement passed pursuant to the order passed by the.
So till then, we'll keep the things in a suspension, state of suspension.
Yes.
No fishing till then.
My lord, I have to mention, my lord, based on the 6, my lord.
Yes.
Their allegation is my technique, which was victim. But in fact, it was not victim.
The learned single judge did not adjudicate that aspect. That is a problem. There is no adjudication.
In record, my lord, in record, there is nothing.
If there had been a reason, even a line of reason, that observation is without any foundation. Can you justify? Tell us. So you argue again. We are not saying that you will not be given the opportunity. Argue, satisfy the court, get a reasoned order. No, we'll pass the order, dispose of.
In meantime, my lord, they are fishing that part of party.
So let the fish survive for a few days.
Allow the infant.
Kind of lesson.
This is otherwise an egg-laying session. No fishing activities allowed.
Fishing went.
So cool your heels for a while.
Till July 15.
Doesn't matter. There are a lot more areas to fish. If required, the court can extend the time. If there is a delay, the court can extend the time. Yes. हो गया? ये कौन सा था? This was item number. This was 43. We have taken up. Disposed of. Yes. हो गया यार काफी. Remaining matter. Yes, please.
46 and 47 items. Basically, fixing on 15/6.
July. Take a date in July.
17 July.
Yes.